Good morning, everyone. Let me start by expressing my gratitude for your presence here. I look forward to this exchange. And as I said yesterday, I am really curious about these ideas around law and because I think we have a really good chance of reprising the role of law as a tool for social justice. And in whatever area of law or discipline that we involved in, I think this idea to rethink about how we deploy legal infrastructure for protection of human rights, for sustainability governance, for other efforts in social justice, I think is ultimately worth it. And I'm looking forward to the various panels that we have over these next 2 days. I just want to highlight some of these for us before we continue. So we have the first workshop on migration and minority rights. This is a key topic, particularly now, where it seems far-right politics have become quite vogue in Europe. And it's interesting to see what kind of perspectives find a voice amongst the current turn to the right. And this is also connected a little bit to panel 4, which will focus on citizenship and the state. I'm grateful for the contributions that we here in this panel. I have a special interest in panel 2 myself because it focuses on sustainability and belonging. I've argued for some time that the way we do environmental law and sustainability governance has to be undergirded by human rights. There was a time when this was a novel approach, a new idea, but now it's nice to see that it's an idea that has come of age, and it's no longer strange to make this claim that somehow human rights have to underpin our efforts in this regard. We have a panel on theorizing belonging in the context of African ecosystems. This again is really, really important. I think it's about time that we reprise the proper constitutional place for African ecosystems. Colonial ecosystems sought to suppress and destroy African ecosystems, but they've still survived. And so there must be something special about their resilience, but also their efficacy and legitimacy amongst various polities across the continent. And I would like to learn from all of you about how we see the future of African ecosystems. And last but not least, definitely, it's the panel on human rights, dignity, and belonging. Again, a special topic of mine, and I'm really looking forward to listening to the perspectives from this panel. I would like to give some special thanks to friends of mine that have traveled from near and far to be here. This is very much appreciated. It is hard to join events like this because they are always competing priorities, and so I don't take this lightly, and I'm really, really grateful that you could be here. I would like to also acknowledge members of my chair who have worked tirelessly to make this event possible. Arranging big events like this is not easy, and it's always a team effort. So I'd like to acknowledge your efforts and everything that you have done to make this a success. For those that are joining us online, I would like to welcome you, especially. I hope that you can have this experience with us and that you are able to participate together with us as fully as the technology allows us. Right now, I'm trying to get the list of the institutions that have supported this event so that I can acknowledge them here also. So this conference has been made possible by the generous support of the Mark-Stiftung in Bayreuth, the Universitätsverein, and the ERWI Alumni Verein. And for their support, we are really grateful. And with these few words, I would like to invite our first panel. And Anne-Doreen will be so welcome everyone, and let's enjoy this festival by doing. Thank you.
Hello, good morning again. Welcome. I would like to ask the presenters to come here in front. We have Philipp, we have Milka, and others will join us online. Milka, welcome.
And maybe two more points that I forgot to mention a second ago. We have scheduled the speaking times for presentations to about 15 minutes and 10 minutes of subsequent discussion. This would be the ideal way, so everything checks out as it is on the program. But right now it looks like that for the first slot, we will have a bit more leeway, so more time to just stand around and get coffee, because we just received notification from one of our speakers, Esther Gumbo, that she cannot make it for this morning time slot to present due to unforeseen events. She may present at a later time slot of this conference. So just give us a second, and then you can, or maybe you can already start try to share your screen in case you have any slides for us, or unmute to see if the Zoom audio is working.
Oh, I forgot to say that coffee and tea and other drinks are just outside. So feel free to grab a cup if you.
Yes, I just wanted to maybe test. So our two first presenters, may you try to unmute yourself and see if the Boom audio is working for us, and we can quickly confirm that. And if you would like to present some slides, you can just click the share screen button and we should be able to see it here. Yes, so the first one would be Tobiloba, Awotoye, and Yewande Fatoki. May you please try to unmute yourself and see if we can hear you in Zoom. Okay.
Good morning.
Good morning.
I see that you started screen sharing.
Okay.
Good morning. Can you hear me?
Thank you very much. And Shireen will now introduce you, and then you can take over from here.
Yes.
Thank you.
All right.
Thank you. Welcome. For this first panel, we are going to talk about migration and minority rights. My name is Ange-Dorine Irakoze, and I'll be guiding you through this session. We are here to explore how migration intersects with minority rights and to think critically about their contextualization within the overarching theme of law and belonging. So before we begin, maybe I'll share a few housekeeping notes. Presentation will run for about 1 hour and 45 minutes. We were supposed to have 4 presenters, but we only have 3. With 2 presenters who will start, and each of them will have 20 minutes. And after that, we'll have a moderated panel discussion for Q&A session. So for those who are following us online, they should mute their mic, and we'll give them to share their comments and ask questions later on. So let's start with a few key points to frame our discussion. Migration is not just about crossing borders. It is about access to rights, protection, and dignity. Yet, in many societies, migrants, especially those who belong to ethnic, racial, or religious minorities, face exclusion, criminalization, and denial of full membership in the community. We are excited to have a distinguished panel today of experts with us who will discuss one of the most pressing ethical and human rights issues in the context of law and belonging. So allow me to introduce our first speakers who will both be contributing in a paper as co-authors. We have Tobiloba Awotoye, is a seasoned legal practitioner and senior lecturer at Leeds City University with over 14 years of experience, with a specialty in labor, constitutional, and human rights law. And he is also known for effectively bringing doctrinal legal studies with real-world application to advance legal education and practice in Nigeria. He earned his LLB at Leeds City University before proceeding to secure an LLM from the University of Birmingham, UK. He is a member of both the Nigerian Bar Association and the National Association of Law Teachers. We also have with us Fatoki Yewande. She is a legal scholar and senior lecturer in the Department of Public International Law at Leeds City University, Nigeria. Her research includes a broad range of topics within African jurisprudence and legal theory. with a focus on rethinking justice from inclusive and context-specific perspectives. She examined the relationship of criminal justice, gender justice, intergenerational justice, and victims' justice within legal system. Deeply committed to human rights, she advocates for the protection and inclusion of vulnerable populations, especially women, children, and persons with disability. They are going to speak about ethnic minority rights and the challenge of belonging in Nigerian's legal system. So in their presentation, they analyze the legal challenges faced by ethnic minorities in Nigeria, highlighting gaps in constitutional protections and the tensions between national unity and ethnic minority rights. And in their paper, they conclude with a strong and more inclusive legal reforms that is needed to ensure full participation and belonging for all citizens. So if you allow me, let me welcome them and allow them to share their thoughts. They have 20 minutes for the presentation. If they can hear us, they can already start the presentation.
Thank you. Thank you very much. Good morning, everyone. It's a pleasure to bring this paper or to present this paper this morning. The topic, as read by her, is ethnic minority rights and the challenge of belonging in Nigeria's legal system. I'll be presenting with, my name is Awotoye Tobiloba, and I'm presenting this paper with Fatoki, Yewande. I'll just go straight to the crux of the paper. Now, Nigeria is a beautiful country. You must have heard so many things about Nigeria. Nigeria is the most populous Black nation in the world. It is so it's a very important nation in the scheme of things, global politics and global human rights and all that. And one of the things, the most special things about Nigeria is that it houses over 370 ethnic groups. And but of course, we only know of 3 of those groups. We know of Hausa Fulani, we know of the Yoruba, and of course the Igbo ethnic groups. And these 3 groups dominate politics in the country, even though we have more ethnic groups. We have the Thieves, we have the Ijaws, we have Urobos, we have Idomas, over 370 of them. And each of these groups have their distinct identities, they have their peculiarities, they have their facial marks, which we call tribal marks in this part of the world. They have their traditions, they have their belief systems. So they are peculiar in their ways. Although, yes, some of these groups have their similarities, but they are distinct. However, we only know of 3 of them. We know of Hausa Fulani. In fact, the Hausa Fulani are different. We have Hausa and we also have Fulani. But over time, we have merged these 2 together. Hausa Fulani occupying the upper north. We have the Yoruba occupying the southwestern region. And of course, we have the Igbos occupying the southeast and south-south. Of course, as time goes on in this paper, we discover that that is not the case. Now, the territory that is now known as Nigeria was not Nigeria earlier on. It's just a British creation. It came into being in 1914 as a result of the amalgamation of the Northern Protectorate, the Southern Protectorate, and Lagos Colony. So the essence of that amalgamation was not to give people the sense of belonging. It wasn't really about ethnic equality. It was just for administrative convenience. It is about the need to control the country or to control the entire region, later to be known as Nigeria. It was about economic efficiency, administrative convenience for the ease of trade. And of course, you know how, how that has transformed. Of course, Nigeria today is faced with so many challenges. Now, this map that you're seeing is what the amalgamation of the Northern and Southern Protectorate did to the region that is known as Nigeria today. We have the Hausa Fulanis, we have the Yoruba, that is Yoruba, and of course we have the Igbos. But this is a good reflection of what Nigeria is. It's not just about the Yoruba. We have the Nupe, we have Gwari, as I said earlier, we have the Bauchi, we have the Baburu, we have Hausa, and of course, all the other regions. But this is what colonialization has done to the region known as Nigeria, to this country. So what are the problems that we've seen or that we've observed so far? We have smaller ethnic groups struggling with underrepresentation. As I said earlier, we have just 3 regions or 3 groups, ethnic groups, dominating politics, dominating the economy, dominating every aspect of life in the country. That is the Yoruba, the Hausa Fulani, and of course the Igbo. We have ethnic minorities facing the barriers to political representation, land rights, cultural preservation, even though the Constitution provides for ethnic equality. It provides against discrimination, but in reality, that's not the case. So what we intend to do today is to analyze the legal protections for ethnic minorities in Nigeria while exploring how these laws affect their sense of belonging to the Nigerian state. And secondly, to investigate constitutional and legal provisions on this and how these are translated into ethnic equality and of course, in promoting their sense of belonging in the country. Let me just go to conceptual clarifications. There are 4 concepts that we are working with today. We have human rights. And of course, we know that human rights is about not just rights of the citizens as we have here, it's about the rights that all human beings enjoy. And we have that in chapter 4 of the Constitution. Chapter 4 provides for right to life, right to freedom of expression, right to personal liberty, and the likes. But we also have something called Chapter 2 provisions in Nigeria under the Nigerian Constitution. These Chapter 2 provisions are peculiar in that they are non-justiciable. And that's where you have rights to cultural heritage and protection of cultural heritage. That's where you have rights relating to ethnic equality. But these rights are non-justiciable. That is, you cannot take it to any court of law for the court to adjudicate on it. We have group rights. It's not about rights of individuals now. It's about protecting the collective needs of individuals in a group, in an ethnic group. Of course, that relates to ethnic minority rights too. And of course, belonging, which involves social and cultural inclusion in the society for everyone. Now, belonging is not just about being present, it's about being involved. It's not about being needed, it's about being accepted. It's not just about being invited, but of course, you have to be supported also. It's not about being heard. It's not just about being befriended. It's about being known. That's belonging. So that means each ethnic group must not just be needed, they must be accepted. But we face that challenge of acceptance in Nigeria today. Before I continue, let me cite the example of the Niger Delta people. That is those in the south region of Nigeria. That's where Nigeria gets most of our oil from. But that region is one of the most underdeveloped regions in Nigeria today. And they have that issue. You also have the IPOB, that's the independent people of Biafra. These people are clamoring for independence. They want to secede from Nigeria because they believe that their rights are not being adequately represented. And they believe that they are just, minorities in the scheme of Nigerian politics and other things. Now, let me go straight to federalism. Federalism has an impact on ethnic equality in Nigeria. We've tried so many things in Nigeria. We've tried federalism. We've tried unitary system of government in the country, but it didn't work. Now, because of the diversity that we enjoy in the country, federalism was proposed in 1954. Now, has that federalism really helped us? The answer is no. In fact, it complicates issues. I'll give 2 examples of that. The first example is that of the senior school certificate examination that we have in Nigeria. We have 2 authorities that regulate this. We have NECO, that's National Examination Commission of Nigeria. We also have WAEC, which is a regional one that is regulated by the West African body. Now, we have 3 languages recognized, or 3 languages that you have to do exams in, both in WAEC and NECO, which does not reflect the diversity that we have in the country. So that means if you're an Ijaw man, you still have to do Igbo language. If you're Robo, you still have to do Igbo language or study Igbo or Igbo language for you to pass. And of course, that's the system. Another example is Section 55 of the Constitution, which provides that the language of the National Assembly in their proceedings must be or can only be four. We have English, Yoruba, Hausa, and Igbo. So regardless of the ethnic group you're from or the ethnic group you are representing, you are only allowed to speak either of these four languages in the floor of the National Assembly: Igbo, Hausa, Yoruba, or the general language, which is English language. Now, this means that you are also telling the other ethnic groups that, oh, see, when it comes to national politics, regardless of the federalism we practice in the country, these languages are the most important. We do not subscribe to whatever language that you speak, which is not what ethnic equality is about. I've already referred to some provisions of the Constitution, but let's specifically look at Section 42. Section 42 talks about right to freedom from discrimination, which I said earlier, like I said earlier, is justiciable. That is, you can go to any court of law in Nigeria for enforcement of this right. But Section 14.3 also provides for federal character. That is, all the groups or ethnic groups should be represented in Nigerian politics or Nigerian government, which is what the federal character principle is about. Both provisions are vital for minority rights, but they face serious challenges. We will examine these challenges in the course of our discussion. One of the challenges is that of the political will to do all these things. For the average Nigerian politician, it's about the next election. It's about where you can get most of your votes from. It's about, as some people in this part of the world will say, it's about stomach infrastructure. That is what you get in your belly and what you put in your pockets. Anyway, so, but if you check Section 21 of the Constitution also, it also provides for legal protection for Nigerian culture and traditions. So we have laws for all these things. You have constitutional provisions for all these things, for minority rights, provisions that promote the sense of belonging among people in the country. We also have the courts trying to interpret all these provisions. You have in the case of AG Bendel State, that is Attorney General of Bendel State and Attorney General of Federation, where the court supported equal resource allocation for each group or each ethnic group, regardless of the size of the group. You also have the case of Tukur and Gogola State doing the same thing, promoting the rights of minorities in the country. But the thing is, there's something that we call independence of the judiciary, where judges or adjudicators are free to express themselves, where they are free to perform their duties as adjudicators, which we don't completely have or really have in this country. Now, as a result of that, the courts decide against ethnic rights or minority rights, not because they know that that's the right thing or they feel that's the right thing, but because they feel that if they don't do it, it might affect their interests, which speaks to their freeness and, of course, their fairness. We have that in this case, the states and Oladimeji. We have the same thing done in Oronto Douglas and Shell Petroleum Development Commission, and of course in Gani Fahimi and Sani Abacha, which happened during military administration. Do we have government policies for this? The answer is yes. There's a 13% derivation policy, which talks about sending money or giving funds to where resources or major resources are gotten from. For example, the South-South region now, the money gotten from oil, 30% of that money that is derived from oil is recouped or sent back into their system for their development. But experience has shown, or reality shows us, that the people that benefit from this 30% are the elites in that region, not the people that really need the money. We also have a commission known as the National Minority Commission in the country, and their duty is to find out what the rights of the minority ethnic groups are, and of course, how to protect their rights or what their needs are and how to provide for their needs. But what are the issues that we can get from these three legal framework or institutional framework on minority rights? Number one, there's discrepancy between constitutional promises that we have in the 1999 Constitution of the Federal Republic of Nigeria and actual application of these things. As I do tell my students, I always say there's a difference between law in practice and law in the books. Now, in practice or in reality, what we have is not ethnic rights, it's the rights of majority in the country. And like I said, it's about the next election. It's about who will vote for you. It's about who will give you what you want. That's for the politicians. You also have dominant ethnic groups, continued exercise of control in politics in the country. Now, we have something called the zoning system in Nigeria under electoral laws and the like. One thing that happened during the last general election, presidential election in Nigeria, is that we had issues with ethnic groups. We had three major candidates, one from the Southwest, that's the current president, that's President Bola Ahmed Tinubu. We also had Peter Obi, who is from the Southeast, is Igbo. And we also had Atiku. And Atiku is from the northern region. I think it's Hausa, but some people have said that it's Fulani. There's an issue, but we are not here to talk about that issue. So people voted, a lot of Nigerians voted in that line. Oh, this person is from the north, so I will vote for a northerner. This one is from the south, I will vote for a southerner. And this one is from this one is from the southwest, I'll vote for someone that speaks my language, someone that knows what I need or what I want. And this one is from the southeast, and I'll vote for that kind of person because I believe this is my brother in quote. And politicians took advantage of that. Lives were lost. Friendships got broken because people were like, okay, if you are not voting for my Igbo brother, then I don't have any reason to be your friend. So these are some of the issues. And also we have the issue of lack of accountability for violating minority rights. Who holds them to account? Like I said, these rights are non-justiciable. So what do you do when a city president, for example, comes up with a policy that goes against these provisions? Where do you go to? Do you go to the National Assembly? The National Assembly, where the language of the National Assembly, like I said, as provided for by Section 55, only recognizes three major groups. That is, those are the majority ethnic groups, not minority ethnic groups. So who do you approach? Where do you go to? Yes, we have those commissions, but those commissions are controlled by the majority, not even the minority. So there is that challenge. But let's check cases, some interesting cases.
Sorry, Tobiloba, you should maybe consider bringing this to the conclusion, but you have to keep up with the time and you have other speakers.
Okay. All right, I was going to go to the comparative analysis, but let me just go straight to of course, I've identified some gaps, but let me run through these gaps and then I'll go to the recommendations because of time. Now, we have gaps in the current legal system, and one of those gaps is the lack of effective enforcement mechanism. Like I said earlier, there's no will to enforce these laws. There's ambiguity in terms of constitutional provisions for minority rights. Of course, like I said earlier too, political exploitation of ethnic identities for selfish reasons. We also have lack of accountability for violating minority rights, and of course, illiteracy on minority rights. Most people don't even know anything. They are entitled to the crumbs they are getting from governors because they don't really know their rights. Now, in conclusion, before going to recommendation, for Nigeria to realize its constitutional promises and strengthen nationality, it must adopt stronger, inclusive legal and political frameworks for protection of minority rights. But what are the recommendations that I've come up with? I came up with 6 recommendations. Number 1, the legal protections for minority rights should be strengthened. Number 2, the country needs to restructure our federalism to ensure fair resource allocation. Like I said when I started, the reason for introducing federalism or for the introduction of federalism is to make sure that the rights of everyone or every ethnic group is protected. But that's not the reality of things. So we need to restructure our federalism in the country. Number three, we need to create mechanism for judicial oversight of the function of the legislature in protecting the rights of minorities and oversight of the functions of the executive in protecting the rights of minorities. Number four, to recognize minority groups in government rules and culture. And number five, provide stronger frameworks for protecting cultural heritage, that's as we have in section 21 of the Constitution. And finally, to empower civil society organizations to challenge legal inequality in the country. Thank you very much.
Thank you. Thank you. Thank you for this insightful presentation. My key takeaways will be that the normative framework provides for minority rights and a certain sense of belonging. But as you have rightly pointed out, there is a gap between the law in the books and law in practice, especially in judicial, language power, and the federalist system in Nigeria. So you also have recommended some few policy actions, and I hope that we'll have more time during the Q&A session to discuss further on these very important issues. Thank you so much.
Thank you.
Your camera is here.
Oh,
If you look this way, then yeah,
thank you.
but that's okay. Yeah.
Okay, please. Our next presenter, now we are moving to employment-related issues to migrant workers. Our next presenter will be Philipp. He is a research assistant at the Chair of African Legal Studies. He studied law and economics at the University of Beirut and international and comparative law at the George Washington University. In his research, he focuses on business and human rights, corporate compliance, and anti-corruption. Today, he's going to share his few insights on the role of corporate labor policies in migrant workers' sense of belonging in host societies from a social, economic, and legal dimensions. His presentation will explore how migrant workers, despite their crucial role in the global economy, face legal precarity and discrimination, with multinational corporations often failing to implement effective human rights policies, leaving workers more vulnerable to exploitation and exclusion. He will later examine whether improved corporate practices and legal frameworks will enhance migrant workers' sense of belonging and inclusion. Welcome, Philipp. That floor is yours. You have 20 minutes for the presentation. And yes, you can go ahead.
Okay, welcome everyone. And thank you for this introduction. Before I begin, I would like to share something real quick. Already when I was preparing this presentation, but especially yesterday when we watched the movie here and we heard the professors discussing it afterwards, I found myself asking this question over and over again. Am I even qualified to speak about such a topic that belongs to belonging? This is my first real academic presentation as a researcher that is not also part of my studies, having started my current position as a research assistant at Prof. Thoko's chair only a couple of months ago. But I still submitted an abstract and signed up to do this presentation. Further, not only am I not focusing on researching on socio-legal ideas, in fact, I am struggling to identify with concepts like these. I would say that my mind is structured to think in more of an analytical, almost mathematical way, and surely not in emotional or abstract concepts. And yet I submitted an abstract and signed up for this presentation. When questioning my qualification to speak on this topic, I have to stress that I'm from Bamberg. As I explained to Cyprian yesterday, Bamberg is a city less than 70 kilometers away from Bayreuth. Both cities are about the same size. They're both in Germany, both in Bavaria, even both in the region of Upper Franconia. This means that I'm not a migrant. I've studied abroad for 1 year, as Anne-Doreen has indicated, but I've not encountered any migration-related struggles due to my strong German passport and citizenship and overall fortunate situation in which I was born. I've never been feared being sent home, and I've never feared losing my place in society. I'm not qualified to speak on the emotional struggle for belonging, not that of migrants and nor of anyone else really. And I'm not trying to do that. But I still signed up for this presentation that is now coined by my outsider perspective on this topic from an analytical business and human rights perspective. So my first of 2 guiding questions I will present in the end is how does one speak about an emotional struggle, such as the struggle for belonging, who is fortunate enough to never struggle with that, beyond personal relational struggles and crises, but surely nothing close to an existential threat. Setting these thoughts aside and finally starting my presentation, I started trying to think about in which way migrant workers' sense of belonging is impacted by corporate entities. And I decided to classify it into a social, economic, and legal dimension at the center of which stands belonging. Social belonging is the sense of connection one feels with others and the institutions around them. Looking at migrant workers, we're of course regarding them in their work setting that is always shaped by social connection to co-workers and colleagues, and potentially also clients, partners, or an audience depending on the industry. In the workplace, social connection is deeply affected by corporate cultures. And if there are inclusive practices, anti-discrimination policies, or mechanisms for social integration. Economic belonging refers to whether someone feels included in and protected by the economy. For example, being paid a similar wage to be able to achieve the same status quo as non-migrants. But it's more than this. It's also to feel economically included as a full participant as set forth in, for example, the International Covenant on Economic, Social, and Cultural Rights. Legal belonging refers to how someone is recognized by the legal order. Are they a person with rights or a commodity bound by contract? Citizenship comes to mind, but beyond that, in some states, corporate policies even determine legal status through tight visas. So that means that losing one's job means losing one's right to stay, and therefore losing one's possibility to belong. I would say that across all these 3 dimensions, corporate labor policies clearly are decisions that shape belonging and are either acts of recognition or exclusion. This raises the question, how much should corporate entities be obliged to respect these fundamental rights and actually contribute to a sense of belonging? In a more traditional way, we think of rights as obligations only between the state and individual. As an indirect application model. The idea is that corporations are not directly, but only indirectly, either through state regulation or to constitutional law doctrines, like the mittelbare Drittwirkung der Grundrechte, meaning indirect third-party effect of fundamental laws, as the German Constitutional Court once said. Current business and human rights framework very much focus on this approach. The US CSDDD or the UNGPs come to mind. Another approach is a direct application model that states that corporations, especially in situations where they exert state-like power, should be bound directly by rights obligations and fundamental rights obligations. The third approach was presented by David Bilchitz, and he called it a multifactorial framework approach. I would say that this approach allows us to see the obligations of businesses in this specific context in a more nuanced way and apply them to certain scenarios and then derive the exact level of obligations that corporate entities should have from that. He classified it into 3 beneficiary-oriented factors: the interest, Are the rights at stake significant for the individuals involved? Vulnerability, how exposed are the right holders? Here the migrants. Impact, what consequences do corporate actions have on these rights? And three agent-related factors. Capacity, does the corporation have the power to protect these rights? Function, what role does the corporation play in the specific case at hand? And autonomy, how much are regulations affecting corporate behavior really? I thought that applying these factors to my three dimensions of migrant worker belonging, we may create a justification for a more direct application of corporations in certain scenarios. So let's factor in these dimensions again and apply them to all these six factors. Of course, the concrete realities faced by different migrant workers are very different. This is, so I had to focus on one specific case. I decided to focus on the situation in Qatar and the lead up to the 2022 World Cup, since I also wrote my bachelor thesis under Prof. Thoko's supervision on this topic. I will only be addressing two selected factors for each dimensions for the sake of time. Social belonging, so the social dimension first, impact and function. Function. Construction corporations in Qatar working for FIFA didn't just offer jobs. They designed the entire environment in which migrant workers lived. There were worker cities that were intentionally built on the outskirts of Doha and other cities in which stadiums were built, far from public spaces and residential zones. These were not just logistical solutions, this was social exclusion by design. Migrants were physically and symbolically kept out of national life, and there was little to no room for integration, interaction, or for visibility for that matter. Recognition was structurally denied for the sake of efficiency. On the beneficiary-oriented side, impact. The social consequences of this corporate structure were profound. Towards Amnesty International and Human Rights Watch, workers described environments of constant surveillance, verbal abuse, and dehumanization. Daily life was marked by being yelled at, punished for resting, spoken to only as a tool of production. Without support networks or basic communicative freedoms, like the freedom of movement, workers were cut off from the very relationship that enable belonging in the first place. Moving on to the economic dimension, vulnerability and autonomy. Vulnerability. Migrant workers in Qatar were locked into extreme forms of economic dependency on their sponsors or their employers. Recruitment fees, often amounting to several months of wages, left them deeply indebted before they even arrived. This burden, coupled with low and unpredictable pay, made workers financially immobile and exploitable. Corporations knew this, and in many cases relied on it to maintain control. Autonomy. Corporations operating in Qatar enjoyed broad autonomy in shaping their labor policies, especially in economic terms. While minimal labor standards existed, enforcement was weak and often led to the discretion of the company themselves. Multinational firms and contractors had significant latitude in determining wages, controlling housing, and enforcing working hours. This autonomy could have been used to ensuring prompt payment, to offering financial literacy programs, or to establishing worker funds. But in practice, economic policies prioritized cost cutting over any form of inclusion or empowerment. And lastly, legal dimension, interests and capacity. At a basic level, migrant workers had a clear interest in being recognized as rights holders under the law, non-discrimination, and in residency security. Reportedly, migrant workers were at times victims of wage theft and restriction of freedom of movement, and then denied damages or severe rights infringements. Capacity. Corporations operating in Qatar had the capacity to uphold and even exceed national labor laws, particularly once international spotlights intensified before the World Cup. They could have ensured transparent contracts, provided legal aid, or translated documents to support worker access to justice. Yet companies limited themselves to minimal compliance and outsourced legal responsibilities to invisible intermediaries, often to informal recruiters. This led me to the conclusion that in this specific situation, corporations should be obliged directly to protect fundamental rights, as justified by the normative arguments that I just made. And here is the core contradiction for me. The weaker the legal framework, the greater the power, the de facto power of the corporation, yet the less binding the oversight that they are subjected to. The corporations built the stadiums, they housed the workers, they controlled their pay, and they regulated their stay. And yet they were held accountable through voluntary due diligence and vague codes of conduct. In practice, corporate power expands precisely where regulation collapses. And this dilemma, I feel like, only increases in weaker government regimes. So let me conclude with my second guiding question. How should we go about this exact dilemma? I myself do not have an answer to this question, but I still have some final remarks that I would like to make. The assumption that corporate labor policy is an extension and only an extension of state regulation no longer holds in a global economy, especially with the multinational enterprises that hold so much power. The application of David Bilkit's multifactorial approach can shed light on the severity of corporate policies in shaping social, economic, and legal dimensions of belonging of migrant workers. In contexts where their policies de facto regulate, corporations should and must be seen as autonomous agents of rights governance. Legal theory must evolve from a state-centric view of accountability towards a relational framework that recognizes power, function, and impact as the basis for binding obligations. And lastly, human rights due diligence can only hold potential when grounded in legal obligation and not in market goodwill. We've seen that. Thank you for listening to me. I've reposted my two guiding questions, the one from the very beginning and the one from the end here. But I'm also welcoming any other comments. Thank you.
Very much, Philipp, for this presentation. And I really like the introduction of not belonging, but yet you managed to highlight the belonging issue. I really like the three dimensions of the corporate labor policies, how the indirect and direct application model of human rights applies for corporations, and the beneficial-oriented factors and how you manage to factor them into the three levels of dimensions. Thank you so much. I think we have enough time for Q&A session. So people who are following us online can start sending in their questions, comments, observations. Yeah, thank you. Our next presenter is here with me, Milka Wahu. She's a human rights attorney with over 16 years of practical experience in social justice lawyering, and a senior lecturer at Jomo Kenyatta University of Agriculture and Technology School of Law in Kenya. She's the founder and current executive director of AMCA Africa Justice Initiatives, a nonprofit that works through collaborative tripartite partnership with university based on legal aid clinics on one part and grassroots organization on the other part to promote access to justice for women and other indigent communities and persons in Kenya. So for today, she's going to present on identity and belonging for gender, non-binary asylum seekers and refugees in Africa. This is part of her paper, and it explores how gender, identity, and belonging especially for gender non-binary asylum seekers and refugees, are shaped by social, culture, and legal frameworks in Africa, questioning whether human rights law can address their marginalization within gender and nationality-based systems. Welcome, Milka. You have 20 minutes for the presentation, and then we'll open the floor for the questions. Thank you.
Hey, good morning.
Hello.
You want to greet me?
Good morning.
Okay. Let me see whether I can convince you to greet me afterwards. Okay, so when I started to research on this topic and to think about this, I ended up really critiquing my previous beliefs and work when it comes to how have I been analyzing, how have I been looking at issues of solving social justice problem? Because like you have heard, my passion and my focus is ensuring that we're using law and whatever tools we have to solve actual social justice problem within our communities. And so in this regard, I'm looking at the issue of belonging, space, and how it produces property with regard to the position that gender non-binary persons, and this is intersex persons, transgender persons, and gender non-conforming. We call them the gender minorities because they're not within the binary, the common binary categorization of male and female. Within the perspective of movement, migration, but as refugee, asylum, and refugees. My friend was telling me that refugees, there's a difference between refugees and migrants. Refugees is a creation of public international law. And so migrants are not refugees, but refugees will be migrants in one way or another. So when it comes to this conversation, we can actually see that this is a very current debate, and that's what the world is now gripped with as we speak. Just the other day, you got the US president, Trump has been chasing people out of Africans, out of US and saying they don't belong here. And there are all these conversations, and this is happening in so many places, not just in US. And so the question that has come to mind and is on our table is who belongs? Because conversations even have gone into even those who belong here in a way because they have become citizens, but they do not fit within up to a certain generation. They still don't belong. So that question is very, very important. The Supreme Court of the United Kingdom just the other day also had a decision that made decided on who belongs to this particular category. Who is a woman? That, yes, the belonging in the conversation about woman. Who is a woman? And so the issue of belonging is very, very important. And so mostly the debate gravitates towards law, especially in a gathering of lawyers like we are here. And again, if you look at the structure of law, the international, regional, and national, it's mostly used as a tool to determine issues of belonging and space. So that's why we say the law says this about migration, the law says this about migration and all that. But however, pertinent issues have remained unexplored as to what is belonging, what is space, and what actually constitutes space within a framework of structural oppression and inequalities. Within also histories of violence, we have a lot of histories of violence, slave trade, colonization, neoliberalism. We see what the IMF and World Bank is doing to African countries and other poor countries. So these conversations have not been placed properly. So I went to look at what is space actually. And when we were watching the movie yesterday, I was thinking the conversation was really nice, and we're talking about property and space and all that. But also, I kept thinking about space and property that is not physical, the conceptual space, the conceptual property. And so I'm looking at space. What is space? In the ordinary sense, space is like where we are, distance, territories, no, the usual thing. But then there's the conceptual space, which is a reference system by which means we locate ourselves with respect to the world. So that is space. The way it's our reference system. Who are we? Where we locate ourselves as a place that we belong. So looking at Doreen's massive theory, that is well expounded by Sela Kingan, said a space describes a set of things, whether it be ideas, social relations, the object or combination, that provide information to be used to ascertain where we are and who we are. And so, in that case, space has characteristics. It may be social, maybe physical, or maybe conceptual. It's not fixed. It's reproduced, shifted in different and at different times. And that's why law changes also, because it also responds to space. It is very distinct, and it actually determines whether we are in or we are out, inclusion and exclusion. And so space, when subject move, because I'm a subject in a space, I'm a subject in a space like I am a Kenyan Kikuyu person, that is my space. I belong there. But when I moved, I came to Germany, I moved with that space. I have not changed. So space moves. And so when talking about migration, we're talking about people moving with their space. And so will they belong with that space? Will they have structure, find structures which appreciate that space that they came with and provide them an opportunity to live with dignity and thrive? So there's that. And what is belonging? Membership within a community, ownership, political accountability, it's all these things that I don't want to repeat because the first presenter spoke about belonging in broader terms. So it's a state of fitting smoothly, without trouble, and to either conceptual category or material position, which is come to belonging. So belonging can be, you belong, it's a subject-object relationship, like I belong, I am a Kenyan. Or it could be constituting part and a whole, that I am a woman. Or another example is white person and the whiteness. That is belonging that relates to you constituting a part of the whole. So belonging can also be looked at from that perspective. And so when we talk about property, it can be tangible or intangible. And that's what I thought is also an aspect that I saw in the movie yesterday. What kind of property are we seeing when we see people moving from one place to the other? What the lady Manto is really insisting, the property of belonging. And that guy who came and said, sang a song, and they say, oh, you belong because of this and that. So property occurs when a relationship of belonging is held up by space and within the wider social structures and networks. So I don't want to go, I know maybe my time is almost up. So with regard to gender minorities and migration, marginalization comes in two ways. It's actually they're marginalized in two levels. To start with, they do not belong because our social and legal structures only recognize binary sex and gender. So there is that non-belonging. Then the second level is they do not belong because they are outsiders. They came, they did not come. So create something like outsiders, because they're outside and outside in all sense. And that creates a lot of problem because of their lack of belonging and invites violence and problem. So when it comes to law and its relationship with belonging, then law relates with belonging in two ways also. Belonging influences the nature and scope of law. For instance, in Kenya, we sat down and finally decided we are naturally polygamous. Where are we having law that is monogamous? So we brought in polygamy in the law, in the Marriage Act 2024, because law is belonging influences law. The other prong is that law creates spaces of belonging. And for instance, law on gender, binary sex and gender creates spaces of belonging and brings exclusion of the people who are not there. So, and which is a creation. Binary is actually, especially in African context, gender and sex binary is a creation of the law. Research shows that Africa has had all this multiplicity of gender and sex. So law brings in is not a good mediator of belonging because it's also underpinned by ideas of nationality, universality, and neutrality. Because that's like reasonable persons, which pays no attention to what the gender, the sex, the race of that particular person. And we say this produces justice because you are a reasonable person. And then the issue of, is actually law universal? Is it universal in all places? But it assumes universality, it assumes rationality. Is it rational? In liberal democracies like our countries, we have this now, we are using law to decide on belonging. Yet, the truth is, when we pay no attention to space, belonging, and the property it produces, then we end up with injustices. I'm about to conclude that. So, in my thesis, law has become, and actually is a lot, a monopoly holder of violence in our societies. Because it says, I am universal, I'm rational, I'm good, I take your view, all of you, equal, and all that. But then what does it do? It leaves out some people. And so it is justified violence because it's the law. So we need to look at law from that perspective. So I propose that we look at other thesis. The thesis proposes that we look at other ways of finding and solving this issue. So of law and belonging and the space it creates. Look, and we can look at how the other theories, critical theories, race, feminist, queer, and other theories of identity policy have been criticized law as a mediator of belonging and space. So we are proposing that, first of all, we appreciate the limitation of law, of law as a presumed universal protector of the marginalized, in this case, gender non-binaries. And then we shift focus, not just analyzing the law, but analyze the subject, this particular person, the marginalized or unpropertied subject, because they don't have property of belonging, they're outside. We shift focus from that and focus on the spaces and spaces which the subject is situated, so that we can try to find a solution. We also abandon the traditional and sustainable strategies of let's save, mostly we do this is very NGO-ish, save or improve the lives of individual subjects, but also the law and policy a lot of time is just, let's improve, let's do something within the status quo, but see how we can accommodate them. No, we need to specialize the subject within and without, put them in the context of their space, which is their reference system, so that we find how they're located, and so that we can be able to demolish systemic injustices. For instance, the issue of gender. We need to locate the space of gender and minorities within the histories of multiplicity of sex and gender in Africa. That has been written a lot And Professor Sylvia Tamari is one of those people who are paying attention to that. Finally, let's not just say I've got this and that and that. Let's draw on other theories that places subject within space, belonging, and property. Critical geographers like Selakinan explores the potential of property to reimagine the political strategies that could shift complex systemic landscapes and norms so that we can difference belonging and socio-legal approaches that we can take to ensure that we remove the violence that law and other systems continue to visit upon non-binary asylum seekers and refugees in Africa. So finally, spaces we can work and we can be able to deliver spaces that are not oppressive if you are looking within the space and belonging context. Thank you.
This was a really good presentation, and my key takeaways will be around belonging and space, how we manage to show their potential perspective, but also their limitations, and how it continues to widen up the marginalization of minorities, and especially how law relates with the belonging in two ways. And you've also given us some proposals as a recommendation. So thank you so much. This is the end of the presentations. Now we are opening the floor for the questions, comments, observations, and any guidance. Remember, these are papers that our presenters will have to go through again, draft. So if you also have any comments in that regard, it would be really appreciated. Thank you so much. Do you have someone else?
Hi, I'm Farida. Those are so fantastic. I don't see how they can be improved, frankly. Philipp, I was so moved by your positionality talk at the beginning. I thought it took such incredible insight and sensitivity to locate yourself in that way. So I wouldn't beat myself up quite so much. The second point I wanted to make, actually, which I thought was quite very interesting, in terms of your paper, I wondered what you thought about the impact of extraterritoriality. Because one of the things that one sees in human rights, and specifically I teach women's rights, so I think it's CEDAW General Recommendation 28, which is on state obligations, paragraph 22, I think, I have no social life. And so that talks about state responsibilities for corporates extraterritorially. And so I wondered if you might be able to speak about kind of corporate belonging, which has traditionally exempted them from the violations that they commit in usually poorer third world states, and in a way linking them with the last paper in terms of space. You can't violate people's space and say, I don't legally belong to your space, therefore I'm allowed to do what I like, and my space will protect me, in the light, for example, of Nevson, the Canadian Supreme Court case. So that's kind of two parts. Is that all right? Yeah?
Yeah.
Okay. See, I've become German already. Yeah. And the last paper I absolutely love. They're just such fantastic papers, and I promise I won't take the whole session. So you and I can have a little chat about what the UK Supreme Court case actually said. I think it was about a statute. It was about the interpretation of the Equality Act. Mm-hmm. And in the interpretation of the Equality Act, what does woman mean? And woman, the Equality Act is a coming together of multiple statutes, the Sex Discrimination Act from the 70s and the Race Relations Act. And so the Sex Discrimination Act from the 70s had exemptions for spaces. So I used to sit on the board of an FGM charity. And one of the things I remember them advertising was a community worker. And they said they preferred a Somali woman. And I said, are we allowed to do that? And they said yes, because the nature of the work, FGM, required somebody who was female, because, you know, the community is not going to be listening to some bloke talking about FGM. So it's about exceptions to when, you know, the label woman. That doesn't mean that transgender people do not have rights of protection from discrimination. So I think it's important actually to unpack it. It's an 88-page judgment. And the piece that I would recommend to you actually was written before that by my mentor who examined Thoko's thesis, who's John Ikala. And he has this wonderful paper, I think it's in Law and Context, and he makes this wonderful distinction between legal identity, biological, and socio-psychological. And so sometimes the legal identity will require certainty and will require that the registration must reflect the reality at the point. So for example, with adoption, we have long birth certificates and we have short birth certificates. The public will have access to the short birth certificate, which may show who the child was adopted by, but the long birth certificate will show who the original biological parent was, because the law says it's important to have a legal truth at the point. Does it make sense? It's the difference between a photograph and a video. Yeah, a photograph is a black and white picture. This is how life was in Germany in 1956. But this is not how life is in Germany in 2025. Do we see that? It's the same place, but it's a different space, to use your kind of terminology. And I think that's kind of important to recognize that. I'm going to keep quiet. I asked other stuff, but I think it's fair to let other people speak.
Thank you so much. I mean, we have enjoyed this. If you have maybe also comments.
Yes, I do actually, but I wanted to be hushed for.
No, it's fine. We still have time.
Sorry?
We still have
Oh, I'm sorry. Okay.
Yeah.
Oh, well, all right then. So the first paper on Nigeria and minority status, I wondered actually if the comparative part that you didn't get to speak of was going to look at Kenya. Because there seems to be this kind of reinscription of quote unquote ethnopolitics. And it would be interesting for me if you were looking at Kenya and if you were comparing it with Rwanda, where the Rwandans have decided that they're supposedly eradicating this difference that was introduced, during colonial times, of inscribing ethnicity into identity because of the really, really awful things that happened. And it's interesting to me that Nigeria and Kenya in particular, keep seeming to be having these conversations and never seeming to break free of them.
Thank you so much. 5 minutes each. If you want to respond or if you want to.
Oh, and one more, sorry. We're naturally polygamous. Leah and I looked at each other like, who's the we? Sorry, did I speak for you? We'll catch that later. Okay, sorry.
Can take one more question.
Just real quick, Philip, thank you very much. I really enjoyed listening to you from the reflection on positionality, but also the material. And I wondered if you could tell us a little bit about the demography of the migrant workers and moving forward, because this is perhaps a work in progress that you want to continue doing. Would you consider that demography and how the nature of the demography itself shapes how the corporate treats them? So, for example, the question of race and gender, who are the migrants? Just tell us a little bit more about that. And to top up on what you just asked about Nigeria, we have in Ethiopia at the moment, we have this question of ethnic minorities, and I was mentioning Ethiopia
Yes.
And then, I mean, I looked at India and everything, but then I was also wondering the same, but not about Kenya, but Ethiopia. It's a consideration. I think there's an interesting something to be said about Ethiopia too. Yeah.
Thank you.
Yeah.
If there is one more question, because we'll now turn up to online questions. But before we go there, I would like to give you also some few minutes to say something about what the professors have said.
Yes, maybe in response to Farida, if I remember correctly, I think it was section 21 of the recommendation and not 22.
Oh, okay.
No, I'm just kidding. I've never. I have no clue whatsoever, but I think this is a really nice hint towards me. I've not looked into this, but I definitely will. Maybe as a question back to you, the CEDAW is the for the rights of women, especially like in my specific case, the one that the case study that I decided to undertake for this one, it might not be the one that I would like to focus on down the road. It's just to act as an example here of how this multifactorial approach may be applied to a certain scenario. In this specific case, of course, the migrant workers working in construction in Qatar were mostly men. I think 95% or more were probably men. So
I think the extraterritoriality point exceeds CEDAW. I think it's a human rights point now.
Okay.
So I was just locating it in CEDAW, but extraterritoriality, I know it is now accepted in human rights and also in the SDGs.
Okay, okay, thank you. So I'll definitely look into this. And maybe if can quickly also respond to Sarah's, I think the demographical part really depends on the exact case study that you're undertaking. So if you're looking at the one that I looked at right now, might be or will be very and completely different of demography views in other types of case studies. And I agree with you that I do think that these demographic ways and circumstances do actually shape back the corporate cultures and design. But I think this would have to be interrogated at this specific case level. And yeah, as I've said, I've not yet decided to stay with that example really, or to go anywhere else, or maybe even compare different ones. But especially when comparing them, this demographic factor would come into play.
Yeah, thank you very much for that conversation and comment. When I look at the Supreme Court, the decision of the UK Supreme Court, I'm looking at judges who are applying the law, the Equality Act, and looking at the law and paying homage to the black letter of the law. This is the law, what the law says, and this is how it's interpreted. But my basis is, how did the law come into being? Going beyond the law, behind the law, that the existence of the law in itself created a violent space that excluded some people. And so now this law is used by the court to declare our rights, and they can't go outside the law. So my thesis is that law rational? Is that law universal? Is that law as it came? Did it unproperty some people when it was when the law was coming into being, not the law itself, right? What's process? Did it take into account space and belonging of people who are not who are right now provided for in the law? And so, comparing to, for instance, countries, there are countries which don't have sex and gender markers in documents. Countries like Bangladesh, they don't usually have this law does it produce a situation that further excludes and marginalizes? That's a question I'm asking. That's a question I'm asking, not attacking the law itself, but the process of coming into that law. How it's how and the effect it produces eventually, like what you have said, which I consider as part of what we say law can become a very legitimate tool of violence.
Thank you. I don't know whether our presenters online can address the first question, but if not, we can go ahead. We've got one question from this person. It's about using anthropological or social legal methods and approaches to these issues, and how it might move the more traditional law forward. He did not mention who could address this question, but anyone from the presenters can just step in and say something.
Okay, there were certain questions for our panelists from Nigeria.
Yes.
Could you invite them, please? And I see that's Annie Griffiths, and so she's American. Yes,
Way back from way back.
yes.
Okay.
So it's nice that she has joined us, and well, the panelists who are just these questions in every time. I'll welcome her in a bit of one.
Okay.
Yeah.
Tobiloba, can you hear us? Oh. Can you hear us, please?
Hello, good morning.
Sorry?
Yes, sorry, please. I didn't get the question.
We can't really
Okay, yeah, I can hear you now, but I didn't get the question. The question again, please.
Okay. So there was this is the
The question again, please.
Oh, okay. Yeah, okay. So the question again.
Oh,
Yes.
shall I join up with you? We were wondering about who you were going to use as comparators. We're going to do Kenya, Ethiopia, for example, and contrast it with Rwanda, which has decided to get rid of ethnic monitoring categories, naming, because of the conflict that arises out of this.
Yes.
and I had a broader
Oh, okay.
yes, and I had a broader question to follow up on that, because I'm torn about whether entrenching these recognitions for all groups leads to further fragmentation. Is there a formula where we rethink what it means to belong in a constitutional sense that doesn't exacerbate this race for state resources by different groups within the state? Is there a formula that we can imagine that does not worsen what essentially is a clamor for resources based on ethnicity? So I guess this is a political question, but it has the law written all over it, and I wanted to hear your reflections about this this question.
Thank you.
Oh, okay. Thank you very much. Yeah, so let me start with the first question, talking about the comparative analysis. Actually, in the course of our work, we intended to compare, or we actually compared with in the India, South Africa, and Canada. But yeah, but I think somebody talked about Kenya and Rwanda. So I think that's another aspect or another angle that we can always look at again and bring into our discussion, to our paper. By the time I think we have to go back to the drawing board to consider, so as to be able to consider Kenya and Rwanda. But actually, we compared India, we compared South Africa, especially as a result of the post-apartheid, that had to do with the broad-based Black economic back then. And we also compared Canada, which of course also has quite a number of multicultural a number of ethnic multicultural assembly society as well. So those are the areas, the jurisdictions that we looked into. But then I think it will actually be a very nice one to look at Kenya and also look at Rwanda, because I know that Kenya too, yes, they have diverse ethnic communities, and we can see if we can look at if we can able to get some best practices from them and learn from them. If actually that is if we're able to get something out of it that we can work on as well. But then to the other question about how resources are being shared in Nigeria, well, the truth is, oh, okay, sorry. So about how resources are being shared in Nigeria, well, for example, we have this let's use, for example, our oil and gas, petroleum, stuff like that. And we have a particular tribe, I think the Delta, which are South. That's where we generate most of our oil products from. But unfortunately, because they also fall under the minority group, they're not even enjoying every benefit that they're supposed to enjoy. Like some other the major ethnic groups are the ones enjoying all the benefits they're supposed to enjoy, which I think is also very, very unfortunate. They keep having issues, complaining about so many things, gas flaring and stuff like that. The environment is not so conducive as a result of all this gas flaring and stuff like that, and it's not helping. And what exactly is the government doing about it? They're not really doing anything about it. So in a way, you can say that even sharing resources, it's not fair, especially when it has to do with the minority groups. They are not getting as much as as the major groups are getting. I think I answered that. I'm not sure, but then
Thank you.
I don't know if my co-presenter would also want to contribute to it, especially to the first question.
Okay, yeah, you can go ahead.
Okay.
Sorry, I think I missed the first question because my network was.
Okay. The first question was asking why we didn't compare Kenya and Rwanda, and I had to inform the group them that we actually looked into India, South Africa, and Canada, but that I think it would be a very good area to also consider Kenya and Rwanda. So that was what I said. So I don't know if you have any other thing to add to that.
No, I subscribe to that. I completely subscribe to that. We just looked at systems that have been able to incorporate minority rights into their laws, and now they've been enforcing all that. And that's why we looked at the example of South Africa because of their history with apartheid. And we looked at that of India because India is the most populous nation, I believe, in all over the globe right now. And they have over 200 ethnic groups over there. And each language, each culture is recognized by the law. And of course, they have this 50% threshold for minority rights and representation in governance over there in India. And of course, you looked at the example of Canada also, but we didn't look at jurisdictions that also share the same challenge, the same issues that Nigeria has today or that Nigeria is facing today. That's why we didn't put there. But of course, as my co-presenter has said, we'll look at that and incorporate into our paper. Thank you for that.
Thank you. I also think that Prof and Sarah Reid, and they can also share further comments offline for further guidance, because there's some part I didn't quite see in the presentation, and it seems to be new, but it's okay. We are going now to take, we have another question online from Chitzi. Hello, Chitzi. It says, hello. Having identified the lack of political will as a challenge in entrenching belonging in Nigeria, I wonder what role law may play in resolving this problem, or if the problem consigns to the realm of politics. I assume you have addressed this to our online presenters.
Yes, that's right, yes.
Okay, I will just give them 2 minutes to address your question. But we also have another question online from Anne. So maybe Philipp and Milka can also say something about that.
Thank you for the question. Yes, there's a lack of political will on the part of the government. And if you look at Nigeria today, people are clamoring for revolution. They are clamoring for people voting for leaders that would actually represent the interests of the people. But of course, striking a balance between what the people want, particularly what the majority wants, and balancing that with minority rights seems to be the problem. But when you have clarity in terms of the provisions of the law, it makes it easier. And like I said during my presentation, some of these rights, most of these rights, are in Chapter 2 of the Constitution. And Chapter 2 of the Constitution is generally non-justiciable by virtue of Section 6C of that same Constitution. So if this non-justiciability is removed from the Constitution, and you have people being able to fight for their rights in courts of law, then it makes it possible to protect the rights of minorities. And that's why we're saying that law still has a role to play in all this. I hope I've been able to answer the question.
Thank you. Philipp, Milka, any thoughts about?
Yes, maybe in response to Anne Griffith's question, as I've indicated at the start of my presentation, I'm quite new to the socio-legal approach.
What was Anne's question?
It's here.
About the anthropological or social-legal methods and approaches. Yeah.
Yes, so as I've indicated, I'm quite new to this approach in its entirety. And in this abstract and paper that I'm preparing right now, I've explored these ideas for the very first time. But I completely agree with you that it is an important tool to move the law forward. It's something that I also felt and explored just by preparing this very first presentation that I just held.
Thank you.
Yeah, I think yes, I'll respond to Anne. Yes, I agree that we need to think outside the law, and especially when coming up with the law, we need to consider the socio-legal issues, because law does not exist it does not exist in isolation. Actual law responds to society. So law must be placed within the social, cultural, and even political context within which it's applied. And again, the subject, the specific subject, and the spaces and belonging concept that they belong to must also be appreciated, so that you can see that you can be able to have law that is not oppressive or violent, and that actually excludes and becomes a problem. And so social legal approaches like legal geography, critical legal geography, and many others offers opportunity through which we can actually be able to find and look for other ways of making, stopping law from being a contextual to space and belonging. Thank you.
Thank you so much. Do you want to say something?
Well, I want to say a lot, but I don't know. Does anybody else want to speak?
There's time. We have time.
Are you sure?
Yes, we have time. There's 15 minutes.
Okay, then. Milka, back to you.
Yeah.
Is it not true that even when legal recognition guarantees inclusion, there may still be rejection of other people's spaces. So I'll give you a concrete example. African Commission Resolution 275, which is on LGBTI rights and the importance of not having violence. African Commission General Comment number 4 on torture, which explicitly includes torture, degrading treatment of LGBTIQ people. So it's not that the law doesn't see them. Mm-hmm. The law does see them. So the law has acknowledged its violence, if we use your metaphor. But still, they continue to experience violence. So I think it's just the continuation of the de jure and the de facto in many ways. And the second thing I wondered if you could clarify for us, you talked about kind of Africa. So where in quote unquote Africa are people seeking asylum? Because it seems to me that the one place that they can and do seek asylum is in South Africa. Because South Africa explicitly recognizes the 9-3 orientation and takes people of sexual and gender minorities. So where else is your research focusing?
Thank you very much. I love it. This engagement.
Okay.
Yes, yeah, it's very good engagement. Yeah. When we talk about legal recognition, legal recognition itself is a concept of law that also produces undesired effects sometimes. For instance, when we're looking at South Africa, they have recognition, they have law that recognizes transgender person, intersex person. But look at what is happening on the ground. Even the UN has cited them. UNICEF has cited them for killing intersex babies, for being very violent. In fact, compared to other African countries without such law, South Africa leads in violence. That shows you that when the law moves before society, social foundations of the law, because this law has moved forward before the society has come to a point where it agrees that these are part of us. These are humans like us. And so, after agreeing on that space, that they belong to this space, they are part of us. They are here. They are human. Then we go to the law. So most of the time with the legal recognition problem is that the law moved before society. And why is society struggling like that, especially in the African context? Because we lost our society in many aspects, especially when it comes to sex and gender. Research, like I was speaking about, in the context of decolonialization and all this conversation, has shown that sex and gender is actually a concept that was brought by colonial law. Africa had living as human who were accepted and they lived. So binarism was actually brought as a legal concept that unpropertied the others. Now, coming back to where we are now, we have lived within binary for all this long, since we were colonized. Let's say in Kenya, it's over 100 years since the white, the English people came. Now, this society, you want to come and tell them, bring back your people, because they used to be your people, accept them, take them in, without the due process of resocializing them. No, going back to the whole. You just want to impose law. And the people reject and say, no, you cannot just bring law and say we accept them. So there is that social process that has not taken place. And that's the problem with actually laws that deal with recognition. That's the same case with Malta. A very good law on intersex children. Law that exists in its own and people exist. In fact, they close the border to the other European countries to actually do surgeries to escape the law. So that is also a big problem. That's why we are saying, let's locate the law within the socio-cultural processes. In terms of how we resocialize our people, how we package this before we even go to the law and when we go to the law. So it's a 360 conversation. When it comes to the African human rights system and the information and the decision and what, we have resolution to it's 275. Does it actually bring recognition for intersex, transgender, gender non-conforming?
They have an intersex resolution.
So, yes. And we also look at how the same institutions do what we call in practice probate and reprobate. It's the same institution that had the CAL decision, the coalition CAL is African lesbians decision that does not want to see kicked out CAL from the observer status. So we see them approbating and reprobating because this issue is still something. And yeah, we'll continue debating on this. So
No, the CAL decision came before the resolution, so they have learned.
I hope so, because there's the same people we have even at home because the commissioners and what and all that. But what we can say is that we have not reached a point even in the African system where we can see now gender and binary persons are comfortable and taken care of in the law.
Yes, we still have time.
Okay, just a couple. So I think I wrote a book on African migration using literature. And so I have a whole chapter on LGBTIQ. And so I have a subsection that says European fairy tales. And the European fairy tales is that Europe is much more open and welcoming to LGBTIQ asylum seekers. But actually, when LGBTIQ plus asylum seekers present themselves in Europe, they're given severe credibility tests. Show us the photograph, show us your love text, show us, and if you're
examination, you can imagine.
So actually, I think we need to push away from this idea that this, kind of phobia is unique to us. I don't think that it is unique to us. And I think there is now a tendency, I don't want to get kind of all auntie on this, in terms of in my day, when we walked to school without shoes. But I think there is this fantasy that's going on in African feminism in particular about in the olden days, we all lived happily together. And we have forgotten that there has been this kind of, capitalism, individuation, urban to rural to urban migration. So none of us are where we are. So we go back to that photograph video kind of example that I used earlier. But we move away, and you and I can have tea and coffee later. To go back to the first paper in terms of comparators, I really do want to go back to Sarah's point about Ethiopia, because the Ethiopian constitution strikes me as infinitely more impressive and important to look at than either Canada or India. For one reason is because I worry a little bit about our obsession with Western countries. India is not a Western country. I appreciate it. I'll get back to that in a minute. When we have local examples that are just down the road, and I think Ethiopia with its use of nationalities is important. But India, I think, is another kind of fantasy because there's a huge BJP, Hindu, kind of Hinduvita kind of move to push away other minorities and to only focus on Hinduism as the dominant, focus. So I think we need to be careful again in terms of what they say they're doing and what is actually happening in terms of the kind of ethnicization of the national space. And I promise I'm keeping quiet now.
Thank you so much.
Okay, I just wanted to link back to Phil's presentation and maybe complicate it a little bit. Actually, David Belchis was supposed to be here, but he's been called back to finalize some of the judgments that he hadn't written before he moved to Reading. So he was at the Constitutional Court in South Africa. And now he's taken up a chair at Reading. And so he moved. And then they said, yeah, but there's these judgments, and then this is the period that has been given to write. So unfortunately, he could not be here. It would have been really, really interesting for him to engage with you on this multifactorial approach, which I like very much. But I would like to perhaps complicate that a little bit and ask, what do you think would be the added value if you were to consider the interrelationships between these factors, but deploying the approach that Anne asks all of you to adopt, that is to look at anthropological or sociological methods. Just some reflection on that, or none, but yeah.
Thank you.
Yeah, maybe I should have just stressed it in the presentation also. So the multifactorial approach is much more complex and complicated than in his book than I presented it to be for timely reasons. And what I do think is the advantage of integrating these kinds of approaches into this multifactorial approach is that I can imagine that it just helps us to get an even more nuanced idea of how things are and corporate obligations can be justified in the very specific case at hand. So the idea that the more complex and nuanced a perspective is, better you can derive information from that approach, I think can easily be justified. Of course, you can also overcomplicate stuff at some point. But I do think that integrating these social-legal ideas, what I was trying to do with my dimensions, can hold advantages, definitely. I wouldn't necessarily say that it has to be these 3 dimensions. It's just that, you know me, I like to work in these classifications and stuff, and it eases my mind a little bit. But of course, it's my rookie take on exactly what Anne said here. Yeah.
Thank you. Thank you so much. If there is no additional question, allow. Okay.
I didn't respond to the issue of refugees.
Consider. It's okay. We continue. I think the mic was.
Which picture? No, this is my picture now. How?
No, that's not your picture. It's my picture. This is because it's my phone.
Okay.
But this is the name that they are.
But they will be seeing different faces.
Then
Remove the picture.
We can hear you. We can hear you.
Thank you. I'm not sure if I can hear you.
Okay, but it's muted.
Everyone is muted except for us now. Yeah.
Yeah, thank you. I was responding to her question. Kenya actually is arguably the country that have the highest number of refugees and asylum seekers in the country. By sheer positioning, we have war around us, Somalia. So currently we have sorry. No, we don't have war in Ethiopia. Yeah, so 800 and around 823,000 refugees in Kenya, while South Africa an estimate of around 250,000. And so the issue of migration and belonging is a very big problem, especially in Kenya. And even now, the political class wants to incorporate. There's a plan. All my legal terms have flown because I'm into socio-legal space, but incorporate them, like reintegrate. And people are saying, no, they don't belong. You can't. You won't do that. You're doing it for votes, but you won't accept. So it's a big conversation about that. Thank you for that. I think I really want to read your book on migration because I totally agree with you. Actually, the law on migration and all this, especially when it comes to refugee and asylum seeking, has been used so badly, especially in the Western world, that you see that when you go to, there was this case in UK, the Pussy case, the lesbian who went through this whole process, and there was a big campaign championed by a church, and she had been first rejected, then because of this big campaign, she was finally accepted. Now, what does that do? We have who actually produced, she was from Uganda, Sela Kinane writes and asks, who actually produced this condition that made Posse unable to stay in Uganda and to be an asylum seeker in UK. This whole thing is lost. Well, eventually she's accepted by UK, and UK is seen as a hero. No, we are the better country than Uganda because no, we accept lesbians, they are human, they can stay with us. But without asking the background question, the deeper structural issues, how did Uganda in the first place end up there? Where they are this country that treats their residents like this? That's the first question. The second question is, who has continued to fuel that? Churches in the US actually are the ones funding the anti-LGBTI agenda in Africa. So, but in UK, church is championing process cause. So the church stands winning when the church is also part of the problem. So you find out process, space and belonging is lost in the process, and people become heroes who should not be heroes in the first place because we are not asking the deeper question. So I think that is a very good conversation, and I'll continue engaging. Thank you very much.
Thank you. Thank you so much. We use the break, the coffee break to have a conversation offline. So allow me to bring this conversation to a close. Thank you for and all the best as you progress and develop the substantive part of your paper. And thank you for everyone for and nice day. And we are now moving to the coffee break. Yes, thank you.
Join us online. We hope that we can get it. So I'll get the word to pass second to say a few welcoming words, and I check out what they're doing now. So
welcome everybody back to our workshop panel 2 on sustainability and belonging. Unfortunately, there's some drilling going on downstairs, but I hope there will stop sometime. We will see. Our first speaker will be Chitzi Ogbumgbada, who is a lecturer in law at the University of Exeter in the UK, and a member of the Exeter Center for Environmental Law. His research interests lie at the intersection of international environmental and energy law, focusing mainly on energy justice and the law. He is the principal investigator of the Society of Legal Scholars SLS-funded Energy Justice Project. He also leads another SLS-funded project on the law school and climate right. He qualified to practice law in Nigeria, having been admitted to the Nigerian bar as a barrister and solicitor of the Supreme Court of Nigeria. I hope he's there online, and I hope somebody is able to put him on our screen, but I can't see him right now. Is there anybody?
Yeah, that's me. Just a second.
Okay. So there's 15 minutes time for this presentation.
Can you enable me to share my screen?
Yes.
Yeah, please do.
Right. Right. So can I just confirm that everyone can see my screen, okay?
Cannot see your screen yet.
Is it up now?
Yes, you're coming.
All right. Okay. All right. Lovely. Well, it's my pleasure to be here. Good morning, everyone. Good afternoon if you're in Germany. My name is Chitzi Ogbumgbada, and just to start by saying that I'm sorry I'm not, physically present to give this presentation due to a slight complication with my visa. So I'm having to join in from the UK. And then secondly, let me just congratulate the chair of African Legal Studies on the 5th year anniversary and wish the chair, many more years of fruitful research. So my presentation today is basically going to be looking at law and sustainability. And in particular, I'm interested in how law can balance all the competing interests that have been thrown up by the energy transition. And when we're talking about the energy transition, we're also talking about sustainability. But then the overarching goal is how law can enhance belonging. So I'll try to bring all of these pieces together. Right. So just by way of an overview, I'll begin by laying a foundation by talking about sustainability and climate change. Thereafter, I'll look at some of the competing interests which, the energy transition and the discussion around sustainability has, thrown up. Thereafter, I'll also, introduce the idea of aiming for belonging, which is the result of balancing all the competing interests regarding the energy transition. And then I'll examine the role of law. The previous panel has talked a bit about law, and then I'll just try to extend that conversation by looking at how law can be an active agent for achieving belonging, for achieving social justice. Then thereafter, I will conclude with what I feel are the conditions or the means for belonging. That is the means that the law could use in instrumentalizing or at least moving us from theory to practice with respect to belonging. So let's start from the very basic or from the beginning, which is to begin with the idea that sustainability is an important concept in this age. And I think it's actually quite easy to see why that is the case. The reason is simply that sustainability, our fate as humans, is tied to the concept of sustainability. But to understand that more concretely, let's take the case of climate change. Climate change is something that we're all very well aware of. It's been described as a super wicked problem, but that's simply because it presents a clear and potent danger to humanity. Climate change is happening all around us. 2 years ago, we had the hottest month on record, which was July 2023. So climate change is something that, that is really, really, it's a challenge. It's an existential challenge to every one of us here on Earth. Now, when it comes to climate change, sustainability requires something, which is that those agents that cause climate change, particularly the energy sector. And I have to nuance that a bit by saying that the energy sector is a contributor to climate change, but it also holds part of the keys to resolving climate change. So let's look at how it contributes to climate change. The use of fossil fuels, all right? Now, sustainability requires us to phase out those fossil fuels, or if we can't phase them out, because phasing out fossil fuels carries justice questions, ethical questions, which I'll talk about very shortly. If we can't phase out those fossil fuels, then we need to reduce their usage to a bare minimum. And now, if we're going to phase them out, if we're going to adopt substitution, essentially we have to look out for the other energy which we can substitute it for, and that is simply renewable energy, or perhaps more broadly, clean energy. And if we're talking about renewable energy, there are different types: solar, wind, geothermal, and the rest of them. Now, this whole process of substitution can be encapsulated around the concept of the energy transition, which is already on the way. Now, the energy transition needs to succeed. And I think that's a given because, I mean, if we look, for example, at the IEA's net zero report, which was released in 2021, the IEA has argued, as with every other scientific organization, that global emissions have to be reduced to net zero. So net zero is a situation where emissions from different climate sources must be equal to the emissions that are removed. Okay, so we need to achieve net zero by 2050. And that is so that we can keep the world within the aspirational limit of 1.5 degrees Celsius, which was set by the Paris agreements on climate change. So the energy transition absolutely have to succeed. But when we're talking about success, we need to be aware of the indices of success. And I mean, the main goal of the energy transition is to prevent the worst effects of climate change from materializing. But then that is just one index, that is just one goal. There are other indices too that we could measure success of the energy transition by. And one of the most prominent, which is one that really concerns us, is the ability of the energy transition to balance competing interests that have been thrown up by sustainability. Now, I've talked about these competing interests for quite a while now. What are they particularly? Well, let me start by saying that the interests that are competing in the energy transition, they vary in range and intensity, and they come under different clusters. So we've talked about the ecological interest, which is simply to make sure that the energy transition goal of phasing out or perhaps reducing the usage of fossil fuels is achieved. So we can achieve those climate targets either through a combination of market approaches such as carbon markets or the emission trading schemes, or even the CDM, that is the Clean Development Mechanism, or perhaps through non-market approaches, through maybe giving of grants, loans, and all of that. But that's the ecological interest. There is also the economic interest, which is something that really, really concerns me, because of the work I do on energy justice. Now, if you look at the benefits of the energy transition, they are not being fairly distributed to all segments of society. Let's take renewable energy as an example. The use of renewable energy has several benefits. The most important is that it can help with climate change mitigation, but other co-benefits include clean energy access for people who do not have access to energy security, helping countries to rely less on foreign or imported sources of energy, and even job creation. Now, these are all benefits of renewable energy, but guess what? They are not distributed fairly in all corners of the world. So developing countries, particularly those that are low income and also in the global south, have seen their renewable energy systems underdeveloped. And if it's underdeveloped, it simply means that renewable energy penetration is not just enough. So the benefits are not being distributed fairly, and they represent an economic interest with respect to the energy transition. There's also the sociocultural interest, and for this, we need to be able to acknowledge the energy transition's impact on something I call the fabric of life. And here we're talking about things like means of sustenance and ways of life. Let me give just two examples, two very short, quick examples. The first has to do with switching from oil and gas to renewable energy and the impact that would have on jobs that are linked to fossil fuel if we were to switch, as we have been switching anyway in many parts of the world, from oil and gas, from fossil fuels, from coal. People whose jobs are dependent on that source of energy would likely find themselves out of a job. And the same thing too with communities whose lives have been built around that source of energy. Then there's also the other example of transitioning from traditional means of cooking and the impact which it may have on people's cultural persuasions. What that simply means is, I did talk about many parts of the world without access to clean cooking and also electricity. Now, in especially developing, or perhaps many countries of sub-Saharan Africa and developing parts of Asia, people still rely on traditional means of cooking, with open fire. Now, we're all trying to get them to use, electric cook stoves, improved cook stoves, and LPG stoves and all of that. But one thing about traditional means of cooking is that it is intertwined with cultural inclinations or cultural or the mores of the people. So transitioning from that traditional means of cooking could impact on the cultural or the culture of people. And that's, brings that discussion under social cultural interest. Now, belonging. I'm not going to go into the theoretical elements of belonging because the previous panel has done a very good job on that. But let me just start by saying that the energy transition is all about people, okay? People and what impact climate change is going to have on them and their environment, all right? We understand that the environment is also made up of other, organisms, but people are central to the energy transition. And that leads us to the arguments that the people whose interests will be impacted by the transition should be seen, they should feel seen and heard. In other words, they should have their feelings validated. And I guess that's what belonging is truly about, for them to be able to belong to the outcome which the energy transition is trying to facilitate in the first place. In other words, no one should be left behind. Now, if we tease out this idea, we would find two goals here of belonging. The first is that belonging serves an ethical goal, like justice. So I remember John Rawls, one of the foremost, proponents of, distributive justice. He tried to define justice as, being as a concept that considers all viewpoints in society. It is the same thing belonging does here, all right? By considering the ecological, economic, sociocultural interest which the energy transition has thrown up, it is serving an ethical or a normative need or a normative goal. But then that's just one of the goals. The second is instrumental, and that is the fact that belonging is important because without it, we are very unlikely to secure the commitment of all these interests I have talked about. And if we're unable to secure the interest of all these interests, of the commitment of all these interests, then the transition may unlikely succeed. Take, for example, someone who has lost their job because renewable energy is replacing fossil fuel. It is very unlikely that we'll be able to secure their buy-in unless we were to give them, maybe give them some palliative support or at least secure their commitment. So belonging serves those two goals. Now that's the theoretical bit of it. What does law have to do here? What role does law have to play? And my simple argument is that law could help us move from theory to practice. All right, so belonging helps us to balance all the competing interests. It gives us the normative framework, the conceptual framework to say that we need to bring all these interests together in harmony so that everyone will feel seen, everyone will feel heard, everyone's feelings will be validated. And law can be that vehicle from moving us from concept to practice, from concept to operation, all right? And how can law do that? It could do that, or it can do that by simply creating the conditions for belonging to take hold, to flourish, if you will. And law is able to do this because it represents a powerful force in society. I mean, it's not just the Austinian, perception of law or the positivist conception of law. Even the natural law school can still conceive of law as being a powerful force, a normative force that can shape behavior, reorientate behavior to a certain direction. But there's a caveat before we can even start talking about how law can create this belonging. And that caveat is that before law's intervention, there needs to be an open-hearted and sincere dialogue. All right. And it's something that we really are seeing very rarely in today's world, especially within the context of international climate negotiations, where the views of countries, developing countries, are rarely heard or at least rarely acknowledged. So there has to be that open dialogue where all interests would be validated. And I'm going to conclude on this note, which is the conditions of belonging. And I did say that law can help us to create these conditions, can help us to create these means to facilitate belonging. And the means actually, they are more complex than these, and they differ in range and intensity. But these are just some of the examples. The first is that law can create a set of indices recognizing all interests. It could come up with a matrix. And when I say law, I'm talking essentially about whoever wields the law. We can have a separate conversation on whether, on who wields the law and whether that is open to democratic, considerations and all. But the basic idea is that the law can create a set of indices which recognizes all interests as a beginning, as a starting point of creating conditions of belonging. Another example is that law can institute differential treatment in achieving sustainability goals. And we see this, for example, within the international climate regime. I did talk about how, views from essentially developing countries are rarely heard. Well, they are rarely heard, but they are sort of heard in a way. And one of the ways that they are, these views have been acknowledged is through differential treatment in the way, for example, climate change is being tackled. The next is assistance to achieve sustainability goals. So assistance here could take different forms. It could be technological, transfer of technology, which is a site of bitter contestation, particularly within the intellectual property regime. But then that is one of the means of assistance. There is also financial, transfer of financial resources, which is also quite problematic. So the previous COP, that was I think COP29 in Azerbaijan, Baku, Azerbaijan. I think one of the ways it was known was that countries were able to reach a finance goal, all right, but if you interviewed people from developing countries, they would simply tell you that that finance goal, in $300 billion from now up until 2030, would just too paltry, all right? But then that act of giving finance, especially to developing countries to address climate change, is an example of how law can create belonging. There's also capacity building. The fact that many of these countries lack both the human and technical resources to tackle some of these sustainability problems. And finally, there's also, instituting a monitoring and feedback mechanism. So it is not just enough to say, for example, that the law should create a set of indices, or perhaps to institute differential treatment, or perhaps to facilitate, transfer of resources from developed or from wealthy countries to low-income countries. We need to have a mechanism where we check, where we monitor all of these, actions from the law. So through this means, it is very likely that, these competing interests will be accommodated. Of course, there is no guarantee of success, but there is no harm, at least in looking at some of these ideas, because at the end of the day, what we want is an inclusive approach to sustainability. So, well, thank you very much for listening, and I will be very, very interested to hear your thoughts and your questions on this. Thank you.
Thank you very much. Our first speaker, I think I was told that we have our 4 talks in a row and then afterwards a discussion. So if you will be ready to listen to the other 3 talks before, I think this is the way. Okay, our second speaker is Olaniyi Felix Olaniyi Felix Olayinka. I hope this is more or less pronounced correctly. Olayinka is a senior lecturer at the Faculty of Law at Redeemer's University in Nigeria and holds a Doctor of Laws degree from the University of Pretoria in South Africa. His research interests include international law focusing on human rights, sustainable development as they relate to control of natural resources, right to self-determination, climate change, and ecosystem and good governance. He has consulted for world-class publishing firms and law journals on his research areas. He has presented his works at reputable platforms and published in domestic and international journals of high review. His publications are contained in Google Scholar, ResearchGate, and ORCID accounts. We're very happy to hear your talk on the ownership and control of land and natural resources in Africa. The floor is yours, if you can. Oh, yeah, there you go.
Hello.
We can see you.
Greetings. Do you hear me?
Yes, we do.
Hello.
Yes,
Do you hear me?
yes, we can hear you.
Okay, thank you. Thank you for having me here, and I want to
That's network bandwidth is not good. Okay, so you can switch off the video.
Yeah, do you want to turn off your video that we can hear you better?
I want to consider a title, ownership and control of natural resources in Africa. The right of indigenous peoples to develop within the Nigerian economy. And in course of the paper, the presentation, we'll be looking at why a resource-rich continent turned out to be the poorest of the continent, and how the transition from the pre-colonial Africa to the modern Africa setting, how is that impacted on the development of the continent. Because for every state of development, the historical background matters a lot. So that if there has been a truncation in the developmental process of a state or a continent, that should be important for us to look at it. So now I want to be looking at the riches and the resources that are embedded in the place called Africa, such that could have warranted the Berlin Conference to hold, and for the struggle for the control of natural resources that are embedded. So now it is important to say that the communities in Africa, pre-colonialization, were so enormous, even though the technology to discover them was not there. But with the westernization, with the Western involvement in it, the resources were being tapped and being controlled, and such it has been. But importantly, I want to bring us to the fact of what happened in the Berlin Conference, 1884. And that singular effect continued to stare us in the face when the development of Africa is being assessed. What happened in 1884 was that interested Western nations converged in Berlin with the sole purpose to scramble, to conquer, and to partition the abundant resources vested in Africa. And that, in fact, has truncated the mode of transition of Africa till we speak. Talking in terms of, there used to be homogeneity in culture prior to this scrabble and partitioning, but with the partitioning now, heterogeneity factor set in, and the cord of unity has become broken. People who are speaking the same tongue before were joined by people of several other backgrounds, and the Falcon can no longer hear the Falconer. And that is being one of the bane of disunity. Where there's no unity, there cannot be development. So we cannot gloss over that in respect of Africa. Very rich Africa now having these developmental challenges. Now, the paper also looks at the issue of development and wants to take a position that the development is about the individual person's development and the nation's development. And in this term now, we want to extend it to continental development. So there are many provisions in the law which talk about a person's right to development. Development also entails having your education. Your education gives you the opportunity of choosing a vocation of choice. So particularly, I want to read Article 3 of African Charter, which provides that everyone to be free from poverty and to attain economic development. So in course of time, we see how this economic development has eluded the African. So particularly focus on how indigenous legal tradition, which used to hold as a premium the community development, because there was this cultural bonding pre-colonization, pre-westernization, cultural bonding, such that everybody belonged to a community, and the focus of everybody in the community was the community development. There wasn't any personal objectives which contradicted that of community development, unlike what we have now, where there are so many conflicting interests struggling with. So, and that makes this paper to emphasize on the issue of culture and indigenous legal tradition, which the paper presents as being catalyst to development. So that has been, and is being affected seriously on account of the colonization that has taken place. The bonding now is now seriously affected, because as at that time, the brotherhood principles held sway. We are related, everybody was related to one another, and there was community ownership of land, which was the means of the major means of production, and everybody had access to it. The traditional rulers who held the properties in trust for the people, they were doing that diligently and with integrity. And the indigenous legal tradition gave to Africa what law has not been able to do now. It has given integrity to everybody in the community. Everybody was looking was above board. What we know now is as a public sector corruption was absent as at that time, because it was unreasonable for anybody to tamper with what belongs to the community, because we are part of that community. So that indigenous legal tradition has really assisted the growth of Africa before colonization. So that aspect now is now missing in the present day Africa. The law has not been effective to give a corruption-free setting. Corruption-free setting such that to allow for infrastructure to be put in place for commercialization and industrialization. That is the major problem, because when we look at why is Africa not developed, this is one reason why Africa is not developed. That is public sector corruption. Then the question is,
kill all niggers, kill all niggers.
This has happened before.
Hello? Are you hearing me?
We're here.
Okay, good. So, in short, what the paper is saying that the absence of indigenous legal tradition, which used to bond everybody together so that everybody was compliant towards community development, is now missing. And the law is not performing that function for Africa or for states in Africa. So, but you all agree with me that that is the major problem that states in Africa are facing now. The law has not been effective in curtailing public sector corruption. And it is on account of the diverse interests that have gotten into the African setting. Now, related to that, this is the fact that there's now legal pluralism and conflict of laws. Legal pluralism and conflict of laws. This establishes the fact that the communal laws is now subservient, or the customary laws are now subservient or have to be graded by the Western laws. So that means where there's a conflict between Western laws or the common law and the indigenous law, that of the common law will take preeminence. In fact, the standards for the standardization of customary law, which are the principles of equity and are provided under common law. So it is the common law now that regulates the African laws, such that the cultural values are being lost seriously. And it is the cultural values that can call the leadership to their senses. That is to make them selfless and to be committed into development, which is necessary for Africa to move forward. Now, there's this privatization of properties. I've said earlier on that there used to be communal ownership of property. That's pre-colonization. But with colonization and independence of states in Africa, states' property ownership has vested in political leadership that owes it in trust for the people. But the position here is that the leadership is not really accountable to the people again. And the government has gone so large, that are so big, so disconnected to the people, that a leadership cannot easily be brought to account, to give an account. So that's the kind of leadership Africa has now. There's not many states in Africa that have checks and control over their rulers. Even election that can be said that to bring the performances out of leadership have been rigged most times. So now, a governor in a state now controls the land that are within the state. But as I've said, how do you bring him to give an account when he starts to distribute such land that belongs to the state to cronies, political members political party members. So the issue of accountability is the missing gap in governance and development in states in Africa now. So, and the cultural value which makes the leadership to the brothers and the relations to the followers is no more. It used to be extended family system, but what we have now is nuclear system, me and my immediate family. So now I want to talk further on the privatization of public utilities. You see the transition from community ownership of resources, which got to the public ownership of utilities. So, but from the 1980s, the narrative was being spun that the establishment will be much more functional and much more effective, and they can produce at cheaper rates if they were privatized. So everybody keyed into that until it was discovered in most states in Africa that it was the political leadership that fraudulently converted the public-owned properties into their personal belongings. So this one prejudices the interest of the indigenous people, who are the vulnerable people. What used to be ours before is now some few people's properties. And this is a denial of the right to own property of the indigenous people, most of them who are less educated and they do not, so they cannot boast. So what the situation is now saying is that what was held collectively is now being held privately by some people. That is in contrast to what was pre-colonial era. So now another important factor which makes the indigenous people to be vulnerable is the fact that there's this dominant business ventures that evolved in Africa. And the multinational corporations, they are owned by Western countries. They are here in Africa to extract, to mine, and to process natural resources that are vested in Africa. So, but many things are wrong with their operations, because one is the fact that they were after the profit. They were not after, we said they are not after the development of host community or the host nation. They make profit and repatriate the same. So that makes the development of Africa to be in jeopardy. So importantly, work is not being generated so much for the indigenous because the expatriates are brought here and to man critical areas of production. So the multinational corporation, they now control the natural resources of Africa in conjunction with the states.
Felix, yes, I see you are not making a conclusion, and you are past your 15 minutes. So perhaps if you could wrap up, then we can catch up on some of your additional thoughts at the end.
Thank you.
Wrap up now. Thank you.
Thank you. So I've identified areas, lacuna in the area of development of Africa and how the indigenous people have been adversely affected, particularly indigenous people in the host communities where these natural resources are vested in. And the fact that there's this problem of political leadership. The paper wants to make recommendations on how Africa can make its development this time around. We have the African Continental Free Trade Agreement, which aims to have an industrialized Africa. It aims to have an industrialized Africa, but not much effort is being put on the quality of leaders that Africa produces. So the paper is saying that there should be leadership processing such that can bring out quality leaders that are ready to assert the right to self-determination of states in Africa with a view of going manufacturing and making jobs available for the people. So that's leadership processing, quality leaders is very, very important. Then there should be agitation for self-determined development. That means the states should focus on areas of advantage where they have the resources and the stuff like that, where they have the resources for it, the manpower, then the technological know-how, and they can even have indigenous technology to do this. So there should be less dependence on outside nations. So then extraction of mineral resources should be done in a way that is environmentally friendly, because the profit motive alone is not good for host community. So then one hindrance which the indigenous people have been having in their development is this issue of non-recognition of lingua franca, which is not a known language to law of contract. It is called vernacular, but we have not less than 2,500 local languages that are engaged in day-to-day transactions. But the law of contract says they are vernacular and they are not recognized. So if you are talking about participation of indigenous people in production and economic, so yes, I'm rounding up now. Okay. So that's the recommendation. Those are my recommendations. And this is the paper as presented. So thanks so much for listening. You are appreciated. So I believe control. Okay, so thanks so much for having me. Comments will be appreciated. Thank you.
Thank you so much for your talk. We will have the questions later after we have the final two talks of this workshop. The next speaker is Josephine Astfalk, who is sitting fortunately right next to me. She's a research assistant and doctoral researcher at the chair of African Legal Studies here in Bayreuth. Before commencing her PhD project, she studied law at the University of Bayreuth, and if I may add,
I should mute.
Yes, please.
Please stay.
Thank you. Oh, mute.
Mute and stay. They muted. Okay. Yeah, she finished as best of her class, I might say, in the Schwerpunkt Human Rights. So, but also, at the time she was studying, she was holding a Studienstiftungsstipendium in a research now. She focuses on the European human rights system in relation to collective human rights and environmental protection. So,
thank you. Okay, and as we have already commenced with a few disclaimers in Philipp's presentation, this is also my first presentation I'm ever holding in this kind of setting. So yeah, comments are most welcome on how this can be improved. Yeah, so when Professor Thoko first introduced us to the topic of this conference, yeah, I think it was first of all a bit hard for me to kind of see where I want to go with my paper, because I'm a German lawyer and we don't really traditionally look a lot beyond the law. But there was still one sentence which kind of came to my mind. I don't know, I might have read it somewhere. Maybe it also appeared out of the blue, but I doubt that. And this is the question of where do we belong when there's maybe nothing left to belong to in relation to the threat humanity sees of climate change, or some might even call it the climate catastrophe. So yeah, I wanted to look into whether this question and the question of belonging could be used as an argument for the right to climate protection. And I have to say I will be focusing in this presentation on European human rights, but I see here are many people who really have a lot of expertise coming also from other continents. So I'm planning on including in this paper also other views, but I thought I myself am not the most competent to give a first take on that. So I would leave the floor later to you and see whether what I've thought about here in this presentation, would also fit to your views or maybe might, differ. So we will first talk about what I really came up with on belonging as a term in the context of human rights. Then I will be talking about traces of belonging in current climate change litigation, mainly focusing on one case. Some of you might know I've researched a lot about and really quite invested in, which is the Klimasenioren Schweiz in Switzerland. We would maybe translate this to climate grannies versus Switzerland before the European Court of Human Rights. Yeah, and then we have a quick look on whether this entire thing I produced so far even might be relevant or not. Yeah, so belonging in the context of human rights. I was reading quite a few things, seeing what belonging really is, because this concept was completely new to me, and just, again, I'm a lawyer. I really don't have a lot of expertise on it, but yeah, what I could really grasp from the things I read, and also from really the word means to me, it is kind of the necessity for human beings to be part of a particular peer group, to be part of anything at all, really, to engage with a social structure, or to even have a space where dignified life is possible in the first place. So I thought there's, of course, this social dimension of belonging, which is maybe social interaction in society, but really everything we have created as humans. But then there's also the belonging to the environment, which I would like to look at in this presentation, which is a prerequisite to all of this, or at least that's what I think. So if we don't have a space in which we can really belong and create anything, we cannot belong in a social dimension. So I called it the 2 stages of belonging. My boyfriend was not so happy with the terminology, and I was holding the presentation to him yesterday, so maybe you have some ideas on that. So, there's stage 1 belongingness, which describes the connection between a person and the environment. And the environment in this context is the natural environment, consisting of the totality of all natural entities which interact and create a symbiotic cycle. So this does not include any man-made factors such as cities or cultural landmarks. And then there's stage 2 belongingness, which refers to the connection between human beings and the ability to shape one's life freely and safely. Yeah, and it is characterized by, as I mentioned before, intricate human interactions and the formation and preservation of a complex social structure. So when we ask this question, where do we belong when there's nothing left to belong to, we see that there are 2 belongs in this sentence, right? So I was thinking, where we belong to, this can really be, so the first part of the sentence, this can be either the environment, as stage 1 belongingness, or really every social structure we see ourselves in. So also stage 2 belongingness. But when there's nothing left to belong to in this environmental context, would mean to me that the stage 1 belongingness is gone, so the prerequisite of belonging. Yeah, so maybe to make this little concept I've created for my paper, a bit more, or to explain it a bit more, I've briefly chosen this case. Many of you might know because it's been quite prominent in the media, at least in Germany. And it's this Peruvian man who, it is not public law, just private law, but still, who, who's having a claim against RWE, this big concern in energy, who's one of the main emitters of CO2. And he's claiming that this glacier lake, for those of you who don't know, I will quickly summarize, who's next to his little town, will soon eat up this entire town, and the town will be gone, leaving him with nearly nothing. Yeah, and he undermines this with statistics saying this is due to man-made climate change. So the stage 1 belongingness here in this context would be the place where this man lives. And he might no longer be able to live there in the future when there's just water covering everything. And then stage 2 belongingness would be that there's the city the people have created who are living there, which will no longer be, leaving him also with a deep cut in stage 2 belongings. And then we go now to this case I really am invested in. So the quality of the picture is not so much, but it's these climate grannies who were before the European Court of Human Rights last year. And I will quickly summarize this case, and then we will look at traces of belonging in this case, and maybe see how it is relevant for climate change litigation, human rights, or at least what from I feel it might be relevant for. Yeah, so for those of you who have not followed the conversation, those were elderly women, mostly over 70, and they were claiming that their right to life and also a right to a healthy family life was severely threatened due to climate change-caused heat waves, which are occurring in Switzerland way more frequently than they used to in the past. And there are quite a few statistics which say that elderly women are especially threatened by these types of heat waves, and that there's a high proximity that they might die by stroke, things like that. But also that they can just barely leave the house because it's too hot and they are not used to it. So again, looking at the two stages of belonging we've created here, stage 1 belongingness might be threatened because these women cannot leave the house in the manner they used to, because they cannot interact with their natural environment anymore. Yeah, and stage 2 belongingness here would be that they, sorry, I have to breathe, that they cannot interact with their social environment in the way they used to before. So I want to now quickly explain how claims before the European Court of Human Rights, but really many human rights courts in Europe, are made and what is necessary for them to be admissible, which is before the European Court of Human Rights under Article 34 of the Convention, that one has to claim victim status. So one has to sufficiently elaborate that there is severe personal harm which is occurring or will occur with high proximity in the future. So usually in these types of claims here, they will be inadmissible because everybody is kind of, and it's a bit paradox in my opinion, harmed in a similar manner. So nobody is severely harmed specifically because everybody is harmed. But still, this is this principle of avoidance of extra popularis in human rights litigation here. Anyhow, the court decided in this case that victim status was not necessary. The court granted locus standi instead for the association of Human Senioren in Switzerland and said, yeah, in this case, we do not need victim status. It is enough that there is an association who really wants to follow up on this pressing issue we have, which is climate change. So the court kind of wanted to decide this case, but it also still saw that there was really this need to talk about it and also to keep it in conversation in European climate change litigation. So comparing this to the two stages of belonging we have talked about, normally an impairment of stage 1 belongingness, which would be the general environment we live in, which really concerns everybody, because it might also harm everybody when, for example, extreme heat occurs, is normally not enough to meet victim status, according to the preservation of extra popularis. Normally, we would need an impairment of stage 2 belongingness, which talks about specific human interrelations we can also elaborate on. You know, I can say I cannot go out anymore, I cannot meet my friends anymore. This, yeah, can be grasped way easier. So it is interesting now, concluding and coming to relevance, that the European Court of Human Rights has broken this principle here, stating that the danger of living conditions is such a pressing issue that severe singular harm is not necessary in this case. So when maybe there really is nothing left to belong to, it is enough for our European human rights system that this might be a human rights violation after all. Yeah, which brought me to the thought that severe impairment in belonging, yeah, might actually be relevant for human rights, climate change, integration. But yeah, I don't know about all of you, so I'm excited for your questions. Thank you very much.
Okay, thank you very much. So we come to our final talk. Dr. Julena Jumbe Gabagambi, who is a senior lecturer at the University of Milka, Tanzania. She holds a PhD in law from the Open University of Tanzania with a thesis on restorative justice and the integration of indigenous justice systems. Dr. Gabagambi has served in various legal and humanitarian roles, including with NEMC, NOLA, and UNHCR. He teaches criminal law, international law, human rights, and related subjects. The research focuses on legal pluralism, customary law, and human rights in post-colonial African continent. We're very happy to have you here, and the floor is yours.
Thank you. Good morning and good afternoon. I'm happy to be here. Can I be allowed to share my slides, please?
Yes, please.
Can you see my slides?
Yes.
Okay, thank you. So my title is Environmental Justice in Tanzania. And look at the quest for the use of indigenous knowledge in environmental management. And my outline consists of the meaning of environmental justice, principles of environmental justice. Then I'll be providing a few examples on environmental injustices in Africa and Tanzania, but also the guiding laws on environmental justice. And then I'll be looking at the quest for indigenous knowledge on environmental management, and then I'll have a conclusion. So with regards to environmental justice, as we might all understand, it's all about giving a fair or equal chance to everyone, regardless of the culture, race, ethnicity, or socioeconomic backgrounds that they deserve, as far as the environment is concerned. So we have to ask ourselves, are citizens having equal access to decision-making as far as environmental justice is concerned? This we might answer from wherever we are on what is going on in our communities. And then with regards to the principles of environmental justice, we have the principles of equity, participation, accountability, and sustainability. So since I'm looking at the indigenous knowledge, we find that pre-colonial societies, they used to involve citizens or communities in whatever they wanted to decide on as far as even environment issues. But with the colonialism, these indigenous knowledge were considered to be barbaric. So by and large, they were left aside and people no longer participated in matters that affected them, even on environment. But again, on issues of accountability, we see that sometimes whenever the environment is being polluted, citizens or communities are not being compensated for the harm that has been caused, or they're not restored back to their status quo. So some of the examples of environmental injustices in Africa, Tanzania, I've picked a few of them, like oil spills in Niger Delta, which caused harm to communities, harm to the fish and all that. But again, you can see that people are still complaining, and they're still complaining in Nigeria as far as these multi-company companies which have been causing harm to the environment, and people are not being compensated, or the environment is not being restored, which is causing harm to the environment, but also to human health. So we also have examples from Ngorongoro in Tanzania, where the Maasai were evicted from their land on the claim that they want to develop the Maasai area, they want to develop issues of tourism and all that. But this has caused disruptions to the Maasai livelihoods, cultural practices, and a sense of identity, because if you belong to a particular place and all of a sudden you are told to leave the place, to leave your land, that in itself is injustice to the Maasai people. And there have been also spiritual drainage, but also separation from their sacred land. But also there has been mining pollution in North Mara, which is also in Tanzania, where water has been polluted, have metals and contamination of all those kind. And there has been clashes with local communities. People are being killed when they go near the mines where these companies are mining. But you can also not see the effect of mining in that area. People are still poor. They're not benefiting from the mines that are mined from North Mara. And since we all understand that mining is not a bad thing, it can contribute towards the development of any nation. But again, if it is mismanaged, then it can bring conflict, but again, also affect the health of communities surrounding the mines. So we might ask ourselves, do we have laws that caters for environmental justice as far as Tanzania is concerned? Yes, we do have the Constitution, we have the Environmental Management Act. These laws covers like the right to life, which in itself includes the health environment. But also we have a duty to safeguard natural resources. And as far as the EMA, it covers issues of environmental protection, restoration, and pollution control. But in these laws, you'll find that we are missing the voices of the indigenous population, of indigenous communities, because when you read the act, you don't see anything that touches on indigenous knowledge, which it is very important as far as environmental justice is concerned, because people must be included as far as the inclusivity principle is concerned, but again, because environmental issues affect them in their daily lives. But again, we have regional laws on environmental justice, which involves the African Charter on Human and People's Rights, especially Article 24, which states that all people have the right to a general satisfactory environment favorable to their development. But again, the Maputo Convention, which encourages sustainable environmental management and cooperation among African nations. And also we have African Union Agenda 2063, which emphasizes on ecological sustainability and inclusive development. But also we might ask ourselves, are we really putting into practice what is provided in these laws? And then we have the UN Declaration on the Rights of Indigenous Peoples, which affirms indigenous people's rights to traditional lands, environmental protection, and participation. But as I've said, in most cases, you'll find that indigenous peoples are not given that right to participate in the protection or participation on protection of the environment. And most of the time they are being evicted from their land just to meet the demands of some of the malt companies. Also, we have the UN Sustainable Development Goals, like goal on climate action, life on land, peace, justice, and strong institutions. So why indigenous knowledge must be central to environmental justice? And I have tried to cover on issues of deep-rooted ecological knowledge, because we understand that indigenous communities possess centuries-old sustainable practices. For instance, management in Ngorongoro. The Maasai have been in Ngorongoro ever since, but you can see that these days they're being evicted from their land and taken to another place to serve the interest of investors. So you can see that indigenous knowledge is being trampled on just to serve the interest of the few. But again, we can talk on cultural survival and human rights. So I would say that displacement or exclusion violates cultural heritage. And this again touches the Maasai evictions in North Mara mining impacts and so forth. But again, we have issues of intergenerational responsibility. Loss of indigenous knowledge is a loss of for all future generations. And I'll say that the pumpkin in the homestead should not be uprooted. For long, Africans have been considered that whatever we have cannot bring good results. But I would say that we had good indigenous knowledge which could be used in environmental protection or environmental management. But again, the indigenous knowledge is important to empower and give chance to be included in matters that affects us. So justice must be co-created with affected communities, and indigenous justice aligns with participation and restoration. But again, it is important to consider indigenous knowledge because we have a legal backup, as I have said, with the UNDIRP and the African Charter. They allow us to be taking part in issues that affect us. So inclusion is a right and it is not an option. So I would say in conclusion that environmental justice in Tanzania requires integrating indigenous knowledge, ensuring fair policies, and actively involving affected communities. And indigenous knowledge is very pivotal in environmental protection. So laws should belong to citizens for environmental justice to be seen to be done. Thank you for listening, and that is the end of my presentation.
Okay, thank you very much. We have now listened to all our 4 talks. It was a very interesting span of different ideas. I might say we started with a very optimistic point of view on the law and how it could help to provide belonging or enhance it. And we ended with a rather pessimistic view on what law can actually do, and maybe it's rather limited. So this opens up the floor for discussions and questions. Okay. I could be maybe have all 4. Or 3 at least?
Yes, I can try. At least, Chitzi, we should be able to see our first presenter.
Yeah. This one. But I can collect shits. Yeah. First one, Will.
Yeah, thank you very much for recognizing me. I've listened very keen interest to the various presentations. The first one by Chitzi, as I think Kirsten has observed, was very optimistic. It paints a very rosy picture, but if we consider issues of power and in the actual implementation or the balancing of interests and how law, especially international law, is used by the global north to maintain its hegemonic status, where do we see the interests of the developing nations? How would they be brought back into the system? And coming to Felix, I didn't quite get the indigenous peoples that you were talking about in the presentation. So empirically, which people or which peoples are we talking about? And for Josephine, it was a very interesting presentation. I think you have started off with a very good note about the interactions of human with the wider non-material world. I think you disclaimed too much. You seem to know a little more. Then when it comes to the last one by Julena, I was wondering whether the Environmental Management Act in Tanzania allows for environmental impact assessments, and whether there was an environmental impact assessment before the Maasai moved from Ngorongoro, and because that is where all these issues, some of these issues probably could fit in. So what was the outcome of that environmental impact assessment on the displacement of the Maasai, unless you have a very different kind of environmental management act, but it's one of these that have been exported all over the place. I'd expect we have to see the environmental impact assessments being carried out before the planned investments. So that's those are my questions. Thanks.
Thank you. I don't see any. Oh, yeah, more questions.
Hi, I'm Supriya. I'm from India and I'm a doctoral researcher at the Friedrich Alexander University. I have questions for Josephine and Professor Chitzi. So I'll first go to you. I was listening to you and I speak about 2 stages of belonging. And I was wondering if it's stage or if it happens concurrently. Not necessarily one following the other, but both happening together. So maybe you already have thought of it, but we'd love to hear your reflection. And the second was a question you posed where you said, where do we belong to, which all has a place-based connotation. What if we were to substitute where with who? Is that even a possibility, and would that change something in your interpretation? So who do we belong to? And the other question is to Professor Chitzi, and I come from the field of sustainability, but I don't often hear the lens of belonging used to talk about energy transition. So I found it very interesting, but when I think of law, it's something more cognitive comes to my brain. It's more rational for me, but belonging has a lot of affective element in terms of emotions also. So what could be the conditions, according to you, that fosters the interaction between the two? I understand it intellectually, but I feel what could be the conditions that can be created for both of them to interact?
Okay, I think it's time for a round of answers now. Maybe we start with Professor Chitzi. Would you like to start?
Yes, absolutely. I mean, those are very, very interesting questions. And just before I start, just wanted to correct a statement I made earlier. The new quantified goal that was reached in Azerbaijan was 300 billion from last year to 2035, not 2030. Let me just go straight to the first question that was asked, which is the fact that the global north is, wielding law and the instruments of international power to subjugate global south, and how to use the expression that power can be snatched or perhaps could be, ranged to benefit the global south. I hope I got the phrasing of the question accurately. The answer to that is that it's not an easy undertaking to do, and that is simply because the structure of the global system is just not favorable to the global south. When we look, for example, at the economic system, it's underpinned, for example, by neoliberalism, and which is something that is stacked against global south countries. And if you even look at several of the multilateral organizations where you've got negotiations between global north countries and global south countries, there is always that bias or that disadvantage that global south countries find themselves. So we have to acknowledge the problem and the difficulty of resolving it. But here's what I think, and I'm very happy to hear if this makes sense. I think that irrespective of how the international system is structured against global South countries, we still have to keep engaging with it. You know, being part of the system is more effective, it's more potent than being out of it. And there is that, in my statement, that subtle rebuke against countries, for example, that pull out of the international system. So, for example, the US has, you know, just withdrawn from the Paris Agreement for the second time, all right? And that's not just the way to go. It can be frustrating for developing global South countries, you know, the fact that their demands may not be met and all of that. But I think engaging with the system, with the multilateral system, is very key. That's number one. Number two is the fact that these countries need to form a common front, especially at international fora. Now, I don't know how it is in other areas of international law. I'm not an expert in those, in some areas, but for the international climate regime, you already have these groupings. So, for example, you've got the African group and the least developed countries group and all of that. These groupings are very important because they could essentially wield power. They could have some, you know, some strength. They could muster some strength in negotiation. These are just some of the ways that, you know, power may be, you know, wielded in favor of global South countries, but it's not an easy fix. And yeah, I don't know if I can answer the second question before, you know, I pass the floor to the other person. Now, the second question has to do with, you know, the interaction between law and belonging, and the fact, and I like the fact that, you know, we're talking about, you know, belonging being sort of like an emotive output, or maybe having an emotive content and all of that. In terms of the conditions that could facilitate belonging, I did touch a few of them earlier, but maybe something I didn't really talk about is the framework, or the normative framework that can underpin that. We didn't really have much time, but my work on justice, you know, has led me to look at, you know, frameworks from Africa. So, for example, the African communitarianism is a framework that I've, you know, looked at, and that framework, that philosophy can serve as a foundation for belonging. So when we look at African communitarianism, for example, we're looking at, if we take the ideas from Thaddeus Metz and Kwame Gyekye from Ghana, we're looking at things like identity and solidarity. We look at identity, for example, members of the community would, you know, see themselves as part of that community. In other words, be essentially enhancing, you know, a feeling of belonging. I believe that can better encapsulate the, you know, sort of the emotive content of belonging. But in terms of the conditions that can facilitate belonging, we still go back to the points I made earlier. Those conditions, the law can create them. The fact that we need to have a matrix or an index, a set of indices that recognizes different interests, that acknowledges those interests. The fact that the law can institute things like differential treatment, assistance, and all of that. I don't know if that answers your question in any way, but happy to, you know, add more details if that's needed.
Thank you. Then we switch to our second speaker, Professor Olayinka. Would you like to answer to your question?
Yes, it's staying muted, so I guess this is enough.
Okay, then maybe later. No, our third speaker.
Okay, so it's okay. You didn't have a question for me, right?
No, I don't believe it.
Okay, yeah, okay. I didn't want to ignore it, so I had to come down. Okay, so I will start with your second question, I think, because so you talked about the question I asked myself in the beginning, right? When there's nothing left to belong to, this is parchment, right? So, of course, one can also belong to society. I think this is more of the typical thing, actually. But from what I was thinking about, so I was having this specific way on what belonging to the environment would look like, and I was thinking that every time we belong to a society or to people in our surrounding, still this is only possible when we have the environment in which we can live in. So this is also why I called it kind of like a prerequisite to really stage 2 belonging. But this is, and then coming to the second question you posed, not both is really happening together. This is what I also mentioned while talking, also why my boyfriend, who I had the presentation yesterday, was not so happy with the terminology, because he said, yeah, really, but it's not like that. You cannot put it like that, because you cannot quite separate it. The reason why I did it anyway, which is kind of just really a way for me to make it easier to then compare it to this idea of European human rights, which is focused on the individual and on whether the individual is experiencing something which might violate a human right, still ignoring that there are so many factors which we actually need to enjoy human rights, which, for example, is the environment, and which was also what I felt like was portrayed in this case I presented to you, that you might need to think differently and acknowledge that there are maybe also other human rights or collective rights, or really just other angles that are as important to us living together in the way we do now. And if we want to continue doing that, maybe we think outside the box. This is also why I was inviting all of you to maybe comment on that, because I think there are really other legal systems we have on this planet to have better approaches to this, or at least, Did this answer the question?
Yeah, more questions, but that's good, right? It makes me think more. Yeah.
And also I wanted to mention, so this stage 1, it's not, of course, it's not absolute. There are many other things which we could put in stage 1, which might not have to do with the environment. Maybe like even willingness to interact or whatever. I don't know, I'm not a social scientist, but yeah.
And what about who rather than where?
Sorry?
I like to wonder the question that she asked you. There was another part.
What if we use who? Who do we belong to instead of where do we belong to?
I use. Is there even a who left then? If there's no place left, are there people left? I don't know.
I heard her who to be who besides the Europeans.
Okay.
Jurisprudentially, because that's the focus of Europe. Europe, as we've acknowledged, never looks at other.
Okay, Professor Becker wants to comment on that.
No, I just wanted to recommend that it's stage 2, so not a cup of tea. Or stage 1, right?
Yeah. I'm confused, right?
So you have
I
time
need
to
to
think
think about
it.
this.
And we have our fourth speaker, would maybe like to answer, which is Professor Gabagambi.
Yes, thank you. Thank you for a nice question. He asked if we have the Environmental Management Act and if there's a provision that touches on environmental impact assessment. Yes, we do have the Act, and it has a provision on environmental impact assessment. Was it done in Ngorongoro before the Maasai were evicted? There were very little consultation with the Maasai communities, and the majority were not ready to move from Ngorongoro. But there has been like constructive forced eviction. So the government did not seek prior and informed consent from the indigenous Maasai residents. And of particular concern to residents are government measures that are forcing residents out of the Ngorongoro. And these include the scaling down of essential infrastructure, including education and health services, restriction on movement in and out of the Ngorongoro, reduced access to pasture, water, cultural sites, and government also employed rangers to assault and beat residents with impunity. And you might see that even the place where they were taken, the communities were not involved as to whether they were ready to welcome the Maasai in their land. And as a result, there has been fightings between the Msomera communities and the Maasai community, because the Msomera communities are now claiming that their land was taken by the government to be given to the Maasai, but the Maasai also are not ready to be taken to these places. Though the government said they will build houses, they'll be given money and other infrastructure, but that has been politicized, and the Maasai are not ready now to be living in Msomera, but the government insists that they have to move from Ngorongoro to Msomera. So it's kind of politicized. And since I used to work with the National Environmental Management Council of Tanzania those days, and I would say these environmental impact assessments, most of the time, they are so politicized in real sense. Yeah, thank you.
Thank you. So we have some minutes left for discussion. If there are any further questions or comments, I invite them. Thoko?
Yes, thank you all for really thought-provoking presentations. I have a question for you, Julena, and it focuses on the hybridity of regulation when it comes to the environment. So there is this traditional way of looking after the environment. Actually, it's a set of laws that we have minimized by calling them customary practice and all that. But these are rules that communities have observed. And I wanted to ask what is your perspective about the place of these sets of rules in the way that the Constitution protects the environment? Are there pathways to constitutionalizing traditional legal systems in environmental governance? That's my question to you. And for Josephine, got a question about the place of belonging as legal infrastructure. You know, how do you see this changing the way we imagine and apply laws, especially for important questions like the one you are focusing on?
And for your answer, I might add two questions myself, if I may. Kind of, I don't know if this is allowed, but I'm doing it.
Yes, I'm sure it is allowed.
Thank you. Yeah. The first one goes to Professor Chitzi, and it's about law and the idea of law that you promote. I think law is not able to balance. It's the actors of law that are balancing, and so what law can do. Maybe there's a difference between common law and our continental law here, but what law can do, it can offer some aspects of balancing that have to be taken into account, but as legal principles or something like that. But maybe that's all. It's rather the result of politics that we should be concerned of. So I think if you would change your term law to politics, wouldn't that be more accurate? Maybe at least from a continental perspective. And to Josephine, you were speaking about two stages of belonging, just terminology. What about two dimensions of belonging? I mean, you want to have this 1-2 stage idea, I suppose, but maybe it's rather different dimensions, not really clear how they interact. Yeah. Any further questions for the final round of answers? I don't see any. So we go.
Yes.
Yes. No. Yes.
No, I've talked enough.
No, you don't. At least not at this panel.
Move to England. I just wanted to connect all of the panelists and ask, actually, I suppose, a different question, which is, to whom is the obligation owed? Is it owed to the community, to the country, or to the globe? Because one of the pushbacks of the Botswana government in terms of the San is this: well, why should we protect this tiny community when the land could benefit the majority country, where development could accelerate as a result of accessing diamonds or whatever is on this land? So that's the first one. And this links up, I think, with the, with the question about, to whom do we owe this duty or this obligation? Is it a local one? Is it a global one? Everybody's giving up on fossil fuels because they've decided it's bad for their local economies. So how do we get past this idea of kind of self-interest, self-being state, as well as community, and take on, which is what I think you're asking for, is the global perspective. And then for Julena, and I think for you too, they're the cases, Julena, these, the Endores and the Ogie cases are both speaking to the same issue that happened to the Maasai. See what happens when you let me speak.
Okay, so great. So Professor Chitzi, you would be the first.
Right. I think I was able to pick up the first question regarding the interaction between law and politics. If, for example, if we should maybe not let politics to usher in some of the conditions of belonging that I talked about. I hope I got that summary right. But if that's the question, I think I wouldn't say it's a question of substitution. I rather would think that it's a question of synergy, all right? So working hand in hand. So we've got the law on one part, and then you've got politics on the other part. And let me explain what that means. And I'll just give an example to buttress my point. Once again, when we look at the international climate regime, it is essentially a set of laws that, guide, or rather, that that are on the responses that countries can have to climate change regarding mitigation and adaptation. But the way that law manifests, the way it comes to being, is essentially through politics. All right. So there's a lot of international politics at play, and we see that, for example, during negotiations. All right, in terms of trying to get the latest manifestations of the international climate regime. So law and politics can work. They don't need to be strange bedfellows in terms of creating those conditions for belonging to take hold and to flourish. Then, for the second question, in terms of to whom do we owe these obligations? That's actually quite an interesting question, and this is just how I want to answer it. I want to answer this question by saying that the answer to that question would depend on the perspective we choose to adopt. So let me just give a more concrete example. Let's take the phasing out of fossil fuels, all right? And the phasing out of fossil fuels will definitely benefit the globe in terms of it's going to help with the fight against climate change. But when you phase out fossil fuels, it's also going to affect countries that are dependent on it. So we've heard a lot about Nigeria today. And Nigeria, for example, depends on fossil fuels, but not just only Nigeria. There are other countries too that depend on that. Now, whose interest should trump over the other? Should it be the globe? In other words, should we owe the obligation to the globe to phase out fossil fuels, or perhaps to Nigeria and other, hydrocarbon countries? Well, it's not an easy question. And like I said, the answer to that is a bit parochial. And it brings us to a starting point, which is, what is justice? All right. This may be a little bit of an abrupt transition, but it brings us to that point to say, what is justice? And that question is not easily answered, because if we say justice is, phasing out fossil fuels, then essentially we'll be looking at the global perspective. We'll be looking at the globe. We'll be looking at, us paying a duty to the globe. If we say, well, justice is also not phasing out fossil fuels because people, some countries and communities are dependent on it, then essentially we owe these people some sense of duty. And that is why we need a meeting point. All right. We need a meeting point where everybody's interests can be balanced. Now, when we achieve that meeting point, then we will essentially achieve belonging, because we're saying that we understand that the globe, for example, needs to phase fossil fuels. But again, we also understand that the phasing of that fossil fuels would essentially produce unintended consequences, as it were. So that achieving that balance is what I think we should really be interested in. It's an ongoing conversation. Very happy to continue it, after this conference. I don't know if that answers your question.
Thank you. Perfect. Let's give another try. Professor Olayinka, is he willing to unmute? The technical advisor here.
And still in the meeting, still not unmuting.
All right.
Okay.
All right.
Maybe he has bandwidth with issues.
Yeah. Josephine Astfalk.
Yeah, so I will be quick. For your question, if I got it correctly, so you were asking how we can use these concepts of belonging and these findings we have to enable change in legal infrastructures, right? Especially looking at these really, really big problems, which are all over the media and in politics, right? So, again, this is only my perspective living here. I have the feeling that with these questions, which are so vivid in political discussions and also in social media, in media in general, it gets really, really hard to ignore them politic-wise. And then, of course, also for the courts, because we are in the end all only people and we follow these discussions. So I think if the outcry of people who are willing to belong, which we all are, I guess, is big enough, as we can see, at least the courts and also the governments, they start, having in mind that this is going on. But still, of course, these are slow processes, and maybe exactly by bringing these issues before courts, letting governments know that this is going on, at least in an ideal world, this would then help shape the law after all. But,